Guten Tag, meine Damen und Herren. Wir begrüßen Sie alle sehr
Ladies and gentlemen, welcome to today's first Basel Conference on the Judiciary on the topic of the separation of powers and the independence of judges. My co-host is Dr. Thomas Stadelmann, who is a federal judge at the Federal Supreme Court. He was awarded an honorary doctorate from the law faculty at the University of Basel for his great international commitment for the protection and strengthening of judicial independence in Europe. With this conference, our Basel Law faculty wants to make a clear signal with that and with our conference and encourage particularly the scientific community to commit themselves to the independence of the judiciary, the separation of powers, and the rule of law. The co-organizer of today's conference is the Swiss Institute for the Judiciary, and it is supported by the European Association of Judges. Its members are provided with a French and an English simultaneous interpretation. It is great to see that there are around 400 participants. Our conference will be recorded and you can watch it afterwards and pass them on to other interested parties. If you have any questions for the speakers, or if you would like to participate in the discussion, you can do that through our electronic chat. Here you can ask your questions in written form, and we will then include your questions and contributions in the panel discussion. The fact that so many of you join us here today confirms how important independence and impartiality of the judiciary are, not only in cultures far away, but recently in Europe as well, unfortunately. This has become a very topical issue because even here, independence and impartiality of justice don't seem to be self-evident anymore. Newest examples for this development, and we're going to hear about them this afternoon, are in particular the EU member states, Poland and Hungary, but Bulgaria and Romania too, and the member states of the Council of Europe and signatory states of the ECHR, Russia and Turkey. This is sad because it was in Europe that the basis of the separation of powers was developed over 250 years ago by Montesquieu. And since then, it has been transferred into a complex multi-layer system of vertical and horizontal checks and balances. And it has since been developed further.
Abgesichert und gestärkt werden dieser
The rule of law in Europe is secured and strengthened by the two European institutional courts. And what we do here has an influence all over the world. Our two constitutional courts are the European Court for Human Rights and the European Court of Justice of the European Union in Luxembourg. They compete with each other to a certain degree and complement each other at the same time. And of course, the national constitutional courts are also part of this partnership. By the separation of power between the executive, the legislative, and judicative branch, we can generally we can generally make sure that there is no misuse of power and corruption. And an independent judiciary ensures a high legal quality and legal certainty, and that people trust the law and believe in legal equality, legal security, and equality in the society in general. With your participation in today's conference, you as participants, you are honored as it honors you as participants, but it also honors our successful efforts to attract renowned experts that you all know. They are going to talk about the theoretical, dogmatical, but also the practical parts and questions around this topic. They will make a critical analysis and compare the different law structures there are. I think that since you are an expert audience, our speakers are very well known to you. So we are not going to introduce them with their extensive curriculum vitae. This is going to save us time for the speeches of 20 minutes. And we have a first European part and then a second Swiss part. And after those two parts, we will have two panel discussions, which will take about 40 or 45 minutes. So we kindly ask all the speakers to keep their time precisely and to stay within the limits of these 20 minutes. So let me introduce to you our first speaker, Mr. Professor Voskuhle from the University of Freiburg in Breisgau, ex-long-term president of the German Federal Constitutional Court in Karlsruhe. The title of his speech is Europe Task Role and Influence of the CJEU in Safeguarding Judicial Independence. Mr. Voskuhle, the floor is yours.
Sehr geehrter Herr Breitenmoser, meine sehr verehrten Damen
Mr.
und
Breitenmoser, ladies and gentlemen, let me first thank you for your attention. I would like to give my talk on the legislation of the ECJ, starting with the constitutional crisis in Hungary and Poland. Article 7 of the Treaty on European Union on sanction proceedings is the article to resort to when dealing with the systemic deficits of the rule of law. But this has proven to be a blunt sword because in order to ascertain that a member state committed a serious and persistent breach of the values set out in this article, we need a unanimous vote in the European Council. These proceedings have been initiated under Article 7, TEU, but a determination is yet to be made. The Commission's proposal whereby member states that fail to comply with rule of law principles can be penalized with monetary penalties. This is called the rule of law mechanism. The European Commission, the proposal for regulation of the European Parliament and of the Council on the protection of the Union budget in the event of general shortcomings in relation to the rule of law in the member states. This has been adopted, but this has been watered down. It is a mechanism that is mutated into a kind of anti-corruption mechanism. Poland and Hungary intend to file an action for annulment against the regulation of the ECJ in the event of such a measure, but according to the decision of the European Council, the decision to activate the mechanism must be taken, and only then can it be included in the guidelines. Against this background, the ECJ has already become active in the past and has used a series of proceedings to grant itself control access according to EU law to check judicial independence at the member state level. The focus is on Article 2 TEU and the promise of the Union of Values to uphold the rule of law. In 2012, in Arman versus Bogdandi, it has been rightly noted that many thought this was almost legal science fiction to activate Article 2 TEU in judicial proceedings. But as in Jules Verne, utopia has quickly become reality. But let's take a closer look. I want to explain the ECJ legislation in 3 phases. The first phase is a prelude, so to speak. I want to talk about the infringement procedure. This was based on a decision taken in Hungary to reduce the retirement ages of judges, prosecutors, and notaries. It declares that by adopting national legislation for judges, public prosecutors, and notaries, this will result in a difference in treatment on grounds of age. In fact, no dogmatic ground or no new dogmatic ground was broken here. Anti-discrimination jurisprudence has always been progressive and not very competence sensitive. But this ruling didn't have a lot of impact, a major impact, because in the wake of the infringement proceedings, the Hungarian government passed a discrimination-neutral law that offered judges who had retired early, they were offered a lucrative compensation as an alternative to their removal. And most of those affected opted for this compensation. Then I'd like to talk about another case. The suspension of European arrest warrants due to unacceptable detention conditions in Hungary and Romania. The ECJ reversed or made the principle of mutual trust more relative. And the execution of a European arrest warrant can be suspended for 2 reasons or 2 conditions. First, objective, reliable, accurate, and duly updated information on the conditions of the detention in the member state must demonstrate the existence of systemic or general deficiencies affecting specific categories of persons or specific detention facilities. Secondly, there must be serious grounds supported by the facts for believing that the person concerned will also be exposed to the risk of inhumane or degrading treatment. With this decision, the ECJ reacted to a decision of the Federal Constitutional Court on the European arrest warrant dating December 15, 2015. Until this decision, it had considered the principle of mutual trust in this area to be practically irrefutable. But important impetus was given by several decisions of the ECTHR on inhumane conditions of detention. But neither the Federal Constitutional Court nor the ECJ could or wanted to ignore these rulings permanently. Now, this brings to the second major phase, and this was almost a drumbeat. This refers to the ruling of the 27th of February 2018, taken by the ACJP, the Portuguese Association of Judges. There's hardly a decision of the ECJ that has been described as groundbreaking, far-reaching, and spectacular. And Leonards even compares it with Van Gent on Loos and Costa ENL. But the subject at hand is actually quite easy to structure. The members of the Portuguese Court of Audits, or the members' salary was actually reduced. But the actual fact was straightforward. In response to the sovereign debt crisis, And in connection with the Union Financial Assistance Program, the salaries of the members of the Portuguese Court of Finance were also reduced by a certain percentage. But it was spectacular because this way was quite dogmatic. The ECJ links Article 19, subparagraph 2 TU with Article 2 TU and Article 47.2 of the Charter on European Fundamental Rights, and takes from these provisions the obligation of the member states to guarantee legal recourse to national courts and effective legal protection. The prerequisite for effective legal protection, according to Article 47.2 TRC, is an independent, impartial court. But the concept of independence presupposes, amongst other things, that the body in question exercises its judicial functions in complete autonomy without being hierarchically linked to or subordinate to anybody and without receiving orders or instructions from anybody, and that is thus protected from outside intervention or pressure that could jeopardize the independence of the judges in this body. But what was that spectacular? Well, I refer to the articles that say that all member states need to make sure that there is legal recourse so that there is legal certainty in the European Union. This is a general supervisory norm for the European Union. But the positive values of this article has become a structure savings clause, basically. So Article 51(2) needs to be discussed as well. And this leads to a situation where all courts of a member state are subject to these norms and standards. So it is a systematic monitoring of the rule of law, even though it is supposed to be about breaches. And then we have the Article 49 of the TFEU, checking the legitimacy of a trial. But this decision leads to a material checking of the system. And this is a danger for the equality in the federal structure. And this legislation has been made more concrete in many rulings and decisions. We have the preliminary ruling procedure. I would like to point to the procedure LM. It defined the potential reasons why a European arrest warrant could be suspended. It also defines the reform of the judiciary in Poland and the infringements in Hungary. So the basic principle of mutual trust says that the criminal courts need to abide by certain requirements, of course. For instance, there need to be independent and impartial. If a person affected says that or proves that there are systemic deficits in a given member state's legislation that might interfere with judges, the judiciary, or infringes their independence, then the authority can suspend a warrant according to a two-tiered process. There were other cases, like the one where Spanish judges' salaries are reduced, or the composition of Polish courts, and the infringement of an independent disciplinary proceeding in the disciplinary chamber, or the changes in the procedure where members of a certain judicial committee were nominated, also in Poland, and the decision's legal protection. The ECJ defined a principle and these things can be read about in the different articles. It is incompatible for the system if judges still get a salary, but the authority needs to check It was made clear with the proceedings in Poland that they did not per se question the independence of the courts, but the affected courts needed to check the independence. The rules to nominate and appoint judges need to make clear that the judges to be appointed have to be independent and impartial, and the respective court or courts need to see into that. There were two proceedings initiated by the Commission on infringement proceedings. The ECJ saw an infringement with judges' independence, but there was a specific focus on the modality of the prolonging of the term of office. This is in the president's discretion, the president of the different member states, but there is a prerequisite for expanding the term of office and its modalities. They need to make sure that they do not infringe on the judges' impartiality and independence. They must not be subject to external interference. There are certain criteria that one needs to observe when deciding to expand a judge's term of office. But the system in place needs to make sure that judges are not subject to external interference. In Poland, judges, there is a rule for the judges' term of office. It's linked to retirement age. So this infringement proceeding is much more effective for monitoring the rule of law in a given state. The burden of control lies with the court. The ECJ's requirement for a systemic analysis in the different member states can overtax certain member states. And there is a danger of repressions in member states coming from the supervisory body or authority. Infringement procedures can also entail the threat to impose fines. The ECJ has its own access to control, and the ECJ has expanded this control, and that was rather dogmatic. The capabilities have been expanded. Article 47 of the infringement proceeding is to no avail, and there's also a lack of other effective control mechanisms, and they need to be alleviated. The costs of this, I call it judicialization, can be quite high in the medium or long term. Article 19, 1, 2, together with Article 2 of TFEU, the ECJ has full access to all non-harmonized fields. That's what it decided on. When checking the democratic rules in a given member state, this modality can lead to basic conflicts at a quite early point in time, I might assume. There are two decisions that might tell us what Germany could expect. There might be a ruling by the ECJ in line with the Article 6(1) from the framework decision of European arrest warrants. And it's not about the member states' attorney generals or a single decision coming from the Minister of the Judiciary. There is a ruling from LG Lübeck and Zwickau that are also interesting. The president of the Constitutional Court in Wiesbaden also asked whether whether a court is actually independent according to Article 267. Doubts were voiced concerning its own independence vis-à-vis the executive and the legislative. This president said that, well, firstly, the judges are supported by the Ministry of the Judiciary and nominated by it. They have to observe the same rules and regulations as official clerks in Germany. And the Ministry of the Judiciary stipulates what kind of databases or programs they have to work with. And judges are appointed or can be appointed for a given period of time. And the internal organization of courts is also stipulated by the Ministry of the Judiciary. I said it before, this includes databases, programs, and also the Ministry of the Judiciary can also decide on judges' trips and journeys. And this is quite shady. So all these reasons that I just explained are not sufficient to say whether or not it is independent. So the control mechanism I referred to before could have led to a different interpretation. So it remains to be seen what the ECJ says about what was decided in Landfurt. But they had a similar argumentation as the court in Wiesbaden. It is really difficult to come to a comprehensive conclusion.
Spannend und auch natürlich, dass Sie die
Thank you very much,
Zeit.
Mr. Voskuhl. That was very interesting, and thank you for keeping your time. I'm looking forward to the panel discussion afterwards with you and the other speakers. Let's go on to Professor Grimm. He is also a former judge of the Federal Constitutional Court in Karlsruhe. He is talking about Europe task, role, and influence of the ECTHR. Thank you, Mr. Grimm. The floor is yours. Thank you, Mr. Breitenmoser. Ladies and gentlemen, the European Court for Human Rights, its task is to enforce the requirements of the European Convention on Human Rights in the member states of the European Council. The most important provision for today's conference is Article 6, Paragraph 1 of the European Convention on Human Rights. According to this article, every person is entitled to a hearing by an independent tribunal. Let me say that independence is only one of the provision's requirements. Apart from that, the court must be impartial, established by a law. It must provide a fair trial, and it must make its ruling within a reasonable time. So you see, we don't have this guarantee because of the judges. They exist because of the people who want to file a suit. The ECTHR has no mandate to harmonize or unify the law of the 47 member states of the European Council. It only acts according to a basic standard of the rule of law. Contrary to the court we have just heard about, because the European Court of Justice is able to harmonize legislatures of the member states partially. The rulings of the ECTHR are not binding, though. The judges need to apply the law when it comes to a dispute. And what is important is that the law, that the rulings are made only according to legal criteria and not, for example, economical or political criteria, or let's say religious criteria. What endangers the impartiality and independence of the laws are the other branches, namely the executive and the legislative, like the politics. In a constitutional state, the judiciary should be independent of the legislative and the executive. So the core of the independence of judges is the freedom from instructions. However, around this core, there are also different criteria. They can influence indirectly the judicial independence. So if judicial independence should work and be enforced, we should also have a look at these points. If we have a look at the ECTHR and the Article 6, paragraph 1, since the 1980s, there are four main criteria which are always considered. First, the process of appointing new judges. Second, their terms of office. Third, existing mechanisms to prevent external influence. And a neutral or independent appearance. However, these criteria don't answer all the problems. So in the course of time, other criteria were added. For example, irremovability of the judges, freedom from instructions, secrecy of deliberations, immunity, that decisions are binding, salaries, and to my surprise, they say nothing about the re-election of judges. And only for a short period of time, this century, we also look at the independence within the courts, which is the independence of judges from the panels, the boards within the courts, and so on, and what plays a role for promotion, for example. How these four basic criteria and the other criteria work together, I'm not sure what their relation is. The criteria I just named could just be could just complement the other criteria. Sometimes they are rather about the internal independence of judges, and other criteria about the external independence. What we can see here is that there seems to be no systematic approach, and I think it is difficult to develop a systematic approach since a judge's work differs from case to case. So the largest gateway how the judiciary can be influenced is in the appointment of judges. So when judges are appointed who are an extended arm of the political branch of the legislative or the executive, then we don't have independent judges anymore. But here we come across a difficulty which is larger than the European Union, who has 27 member states. I think the Council of Europe has 47 member states. So we have a great variety of different legislations. So if you just end what is more, if we just look at member states' legislations, they don't necessarily reflect the state of judicial independence in the respective countries. So we don't really know how it works in practice. We also need the legal cultural background to assess the judicial independence in a country. We do have this option. And we know systems where where the regulations are such that politics could influence the judiciary, but they don't use that possibility. And there are other systems with checks and balances, but still the politics can influence the judiciary. For example, if a certain political party rules a country and is also able to influence the judiciary. Now, the ECTHR says that no system of a Council of Europe member state is actually incompatible with Article 6 of the ECHR. It then refers to the freedom of instructions. And then it says that it doesn't matter how the judges are appointed if they then are free from instructions. But actually, in the appointment of judges, we can influence the process, and afterwards, such instructions aren't necessary anymore because the judges listen to the executive, for example, anyway. And the ECTHR only judges according to the legislature whether the freedom of instruction is upheld. And according to this logic, the snake eventually bites its tail. The Committee of Ministers apparently favors a system of intermediary councils of judges, and many of the former socialist states went over to this system to assign the appointment and promotion of judges to such a body. But that doesn't really solve the question, since we still don't know who is entitled to appoint the members of the body. So the ECTHR doesn't have a clear line here either. There is a different picture when it comes to the time and terms of office. The terms of office are limited by law. So, but there are also legislatures where there are only very short terms of office of judges. The terms of office also play a role when it comes to the question when a judge has to terminate, to leave office. And here we touch upon the question of how judges are exchanged, who follows a retiring judge. So here we don't rely on the legal guarantees, but the legal guarantees are not touched upon if there is no practical implementation. So if we need to exchange judges within a court proceeding, this may work, but it needs to be a legal, but there needs to be a legal basis which doesn't exist so far. So the fourth reason is the appearance, whether a court, it doesn't only have to be independent, but the public or the citizens don't have to believe that they are truly independent. And here to make sure whether this criterion is fulfilled, the ECTHR refers to the three above mentioned criteria. And here again, the snake bites its tail. I actually don't have the time to touch upon examples, but I can only give my assessment here. I think that judicial independence depends on many individual factors. Dangers are present on different levels and come from different directions. And if we want to assess the independence of the judiciary in a country, we need to assess all these individual factors. So if we want to ensure that a judiciary is independent, we need to have a look at the practice and not only at the laws. So what we do at the moment is always only looking at individual factors or criteria or rules and regulation, and then we want to exchange or modulate individual factors. But one factor doesn't decide whether a judiciary in a country is independent or not. So if we talk about the appearance of independence, that doesn't say us much. So if we, as I said, want to assess the state of a country's judiciary, we can't only look at the laws. We need to consider the practical implementations. And there are individual judges who say that we must do more in that field. So the task of the ECTHR to ensure an independent judiciary in its member states can be fulfilled based on the options the court has at hand at the moment. So I'm very honored that a person who is a specialist in this field is present here. She is the next speaker, and all the mistakes I made, you can now remedy. Miss Angelica Nusberger.
Thank you so much, Mr. Grimm, for this informative speech. Thank you so much for these valuable insights into the legislation of the Strasbourg-based Court of Justice. And thank you so much for observing your time slot. Thank you so much. And you have already done a very nice segue to our next speaker, Angelica Nusberger. She is a true expert on this field. She was the vice president at the European Court of Human Rights in Strasbourg. And without any further ado, Ms. Nusberger, you have the floor. You will talk about Europe, the role and possible influence of the Venice Commission. Thank you so much, Chair. Thank you so much for having me, ladies and gentlemen. The speakers who came before me had a huge advantage. They could resort to norms and standards to give them a framework. We heard the reference to Article 19 and 2, and we referred to Article 6 of the ECHR. Now, I would like to talk about the field of soft law. And there isn't the standard we could start from. It's rather an opinion of mine or an experience that I have made. Maybe you know what I'm talking about because we were all judges or experts, and we know how hard it is to strike compromise every now and then. Compromise can be a time-consuming thing, and you need to come up with a compromise everyone is willing to sign. One of the most impressive examples was the struggle in the Venice Commission to reach a common understanding of what is to be understood as the European standard for independence of judges. We were 4 rapporteurs in that group: the Russian Constitutional Court President Zorkin, the Italian criminal law professor Nepi Modena, the retired Icelandic Supreme Court Judge Torfason, and myself. So 4 people, all in all. We were asked to issue an opinion on the independence of judges in Europe. The main problem was the split between the Eastern and Western European parts. While the Central and Eastern European countries were trying to build a new judicial system after the fall of communism in 1989, 1990, and the establishment of councils of judges and certain structural organizational arrangements were regarded as best practice for this purpose, while the so-called old democracies argued that, well, they could not accept certain objective and sensitive standards because they did not think it was necessary, and to translate them into systems that have been worked well, because you should never change a running system. Why should you make something new if this has worked well for decades? If a system works well without judicial committees, why should you establish judicial committees, by way of example? Now, the compromise was the following formula. Firstly, there is a variety of different systems for appointing judges in Europe, and there is not one single model that would apply to all countries. Secondly, in older democracies, the executive sometimes has a decisive influence on the appointment of judges. Such systems can work well in practice and allow for an independent judiciary because these powers are limited by legal culture and traditions, and they have evolved over time. However, new democracies have not yet had the chance to develop these traditions that can prevent abuse, and therefore, at least in those countries, explicit constitutional and legal provisions are needed as a safeguard to prevent political abuse in the appointment of judges. So that means the Venice Commission, that should have reached a common norm for everyone, had to use a compromise that works for Eastern and Western European countries. To me, this seems to be an element that, especially for the judiciary in Switzerland and in Germany, is of huge importance, because we're faced with those questions as to why we do not introduce standards and norms that other European countries have been demanding for many years. So this is to serve as an overview of the Venice Commission's work and the compromise from 2010. And against this backdrop, I would like to comment briefly on some cases in which the Venice Commission was called upon to answer questions, and they introduced some kind of constitutional fire brigade that should come to the rescue and extinguish fires if need be. And I would then like to talk about some methodical questions. Well, I said I wanted to provide you with examples. The first example is Albania. The initial situation was as following. There is a high level of dependence and corruption in the judiciary, which is an endemic problem and has been an endemic problem for many, many years. In some cities, judges applying for a certain judgeship had to pay for those vacancies, and it was sometimes a very large sum of money. It was a lot for the judges or the candidates. Now, this situation should stop. They wanted to introduce a vetting procedure that would have to be done for the already appointed judges and the new judges that wanted to be appointed. So not only starting now, but also in hindsight going back 20 or 30 years. And it also entails the disclosure of their financial assets, not just their own, but also their relatives' financial assets. So it should be a comprehensive vetting procedure done by an independent body. So if someone owns an apartment, but they cannot prove what they had earned to afford that apartment, then this was something one should see into. Some of the judges failed this vetting procedure, and in the Supreme Court, basically no one was left there anymore because they failed the vetting procedures. There was only one female court, but her mandate actually had expired, and that was at the Constitutional Court. So judges or new judges couldn't be appointed anymore because the replacement of the Constitutional Court should have been done by a certain formula: 1/3 President, 1/3 Parliament, 1/3 Supreme Court. So again, the Venice Commission was initiated as a constitutional fire brigade, but basically it did not help the courts. It emptied the courts. In this case, the Venice Commission tried to interpret the Constitution so that the Supreme Court and the Constitutional Court were still functioning. But again, this example of the vetting procedure shows that even the best ideas can have very bad consequences. The best intentions, basically. Empty courts in Albania would have led to a non-existing judiciary. My second example is from Russia, a new example. The Russian constitution was amended, and these amendments are being checked by the Venice Commission as we speak. These amendments also affect the judiciary in Russia. What is new is that the president of the Russian Federation has the right to nominate courts or to remove courts in the Constitutional Court, in the Supreme Court, different courts, different judges. The initiative can start with the president. The requirement is as such: violation of the honor and dignity of a judge, as well as in other situations established by law, which show that the judge is incapable of continuing to perform their duties. That's the requirement. So you will likely end up with two basic problems: the dependence of the judiciary on the executive. Not only talking about the appointment, I'm talking about the removal of judges if the president believes this should be done. And the requirements are quite vague in general. And it is not a European standard, because a European standard says that the definitions have to be very clear and the conditions need to be very clear why a judge has to lay down their mandate. So again, the Venice Commission was requested, and I believe that these examples alone, also on a constitutional level, these examples show that the tendency goes toward a weakening of the judiciary and a growing dependence of the judiciary on the executive. My third example is Poland. My predecessors, the speaker before me, talked about this before. It was in connection with the ECJ. Reforms came from the Constitutional Court. There were reforms of the Supreme Court and reforms of general legislation. And the Venice Commission has accompanied the entire process and issued clear statements and opinions. There was an opinion in 2020. It was about the prohibition to doubt that a judge appointed by the president is a legitimate judge. A violation of this leads to a disciplinary proceeding, so it was not allowed to voice doubts whether or not an appointed judge is legitimate. This would end up with a new extraordinary chamber of the Supreme Court, but this would lead to a situation where the vetting process lies with the same body. And this body is already in a situation where it cannot decide independently and impartially. So these examples, I believe, show that the Venice Commission is resorted to as a constitutional fire brigade, and these examples also show the dimension of the threat of judicial independence in Europe. So what's the function of the Venice Commission? Well, its mission is to issue concrete opinions on current problems it is presented with, referring to independence of judiciary systems. Besides these very concrete tasks, the Venice Commission also should voice abstract standards or define standards that serves as a skeleton to these clear and clearly defined statements and opinions, like the opinion on the judicial independence from 2020. It completely includes the legislation of the ECTHR. It is copied by the Venice Commission, also legislation from the ECJ and international standards like the UN Basic Principles on the independence of the judiciary and further soft law standards. They all flow together, so the Venice Commission can use it to come up with something that can be seen as a European standard. The method is, of course, problematic because we talk of European standards, but non-European standards assess the statements and different soft law instruments that need to be linked together. So the idea of European standards is, of course, a vague requirement that is evolving. To what extent is the Venice Commission's approach successful? Well, it fills a void. The ECJ, Mr. Fosk said it before, the ECJ has become a court deciding on the state's legitimacy. So now the Venice Commission has filled a void. I believe its track record is mixed. In the case of Albania, certain standards have been adopted, and they took the Venice Commission's opinion as an orientation. Sometimes the Venice Commission's success is of medium-term nature because it starts off as soft law and it becomes hard law, so to speak. But Poland, for instance, is not a success for the Venice Commission. Well, I mentioned these three countries, but we're here to talk about Germany and Switzerland. We have similar questions concerning judicial independence. We talked about the Court of Wiesbaden. This court questioned the state of independence in Germany. So we are faced with different challenges in the different European countries. And the big problem is to develop general standards. I believe that there are very well-defined standards. For instance, presidents are not allowed to initiate the removal of judges. But certainly we can discuss the appointment procedure of judges. As to the opinions of the Venice Commission and the development of standards, and this is very important to me. This is what the Venice Commission sees it as rule of law checklist. I believe the rule of law checklist is quite helpful because the rule of law, of course, comes with different interpretations, but the checklist consists of, well, different topics: legality, legal certainty, prevention of abuse of power, equality of rights, prohibition of discrimination, and access to the court, and also independence and impartiality. So what does it do, or how does it work? It develops questions for that rule of law checklist. And these questions, or the checklist, is to be seen as the yardstick that one can apply to assess a state's judicial independence. It's 24 questions that are considered central. Regulations on judicial independence, for instance, the appointment and dismissal of judges, their terms of office, reasons for their removal. Is it appointment for life or limited? Reasons for dismissal, I said that before. And of course, also appeal against dismissal. And this is a central point. This boils down to a legal tradition or a legal culture. Whether or not judges are seen as independent and impartial or the opposite, well, this also boils down to whether or not there is a basic trust in a given country. Is the judiciary considered independent by the population? What is public opinion with regard to possible political influence and manipulation in the appointment or promotion of judges, as well as in their decisions in specific cases? These questions are central. And this boils down to what I refer to as a legal culture. Appearance is very important. Disciplinary proceedings can be used as breaks in a certain country. There were different cases like Volkov versus Ukraine or Ramos Nunes versus Portugal. The ECTHR had different decisions. Of course, there are critical questions when measuring the judicial independence in different European countries. We should apply an equal yardstick. And it remains a challenge to come up with a comprehensive shared approach. Thank you so much, Ms. Nusberger. Thank you for this interesting talk. Thank you for your information and explanations. It was very enlightening. Thank you so much. And we have time for a small panel discussion, which I am about to start now.
We have not received any questions from the audience yet. So we invite all the participants to submit their questions. It was something you might have not quite understood, or something you would like to contribute from your practice, from your work. So we welcome every contribution. Just submit them in the chat or in the Q&A section. So as long as we don't have questions from the audience, I start with a question from my side. So my first question is for all the three of you. Ms. Nusberger, you said that the Venice Commission, as a firefighting unit for the rule of law, tries to bring in abstract suggestions. You also try to find compromises between all the new democracies. So my question is, it comes to a surprise to me when I talk to colleagues in Switzerland and Europe that the efforts of the CJEU and of the ECTHR are not known. For example, how if Mr. Grimm said that the main question is how judges are appointed, we see that in Strasbourg and in Luxembourg lately there have been spectacular changes to ensure the quality and competence of the judges of these highest courts, because this has an influence all over Europe and the member states of the Council of Europe. For example, since the Treaty of Lisbon, we have Article 255 on how the European Union works. We have the 255 committee, and you, Mr. Voskuhle, are not only a member of this committee, but the president. So we have a new example with this body who has a large influence with the expert opinions it publishes. So now's my first question. Here's my first question. Can you tell us something about your work in this field? And maybe as a second question, can you tell us something about the ECTHR in Strasbourg? We realized that it is subject to criticism, which 20 years ago would have been impossible. And we also realized that in the last few years, the judges didn't have the same quality and personality and charisma as former judges. Maybe this has also something to do with the new member states of the European Union. But here we realized that we need a special committee to appoint judges and maybe to refute or to comment the applications which are handed in by member states, so that the appointment of judges is done or prepared by an expert committee. So Ms. Nusberger, when you deal with newer democracies, have you ever referred to these new developments in Strasbourg and Luxembourg? Because I realized that in Switzerland, no one knows these new rulings and these new regulations. We have a Judiciary Commission here in Switzerland, for example. We're going to hear about that. But they didn't really do their homework so far. We now talk about constitutional reforms. And with that, we could think about the reform of these judiciary expert commissions in a way they already exist in Luxembourg and Strasbourg. So that's a question for all of you, but maybe you start, Ms. Nusberger. Can you tell us some examples from Strasbourg and Luxembourg and how you use them in the Venice Commission? Yes, that's a very important point. The appointment of judges who then influence the jurisdiction directly and indirectly. That's a large problem. For example, my mandate ended a year ago, and one of my colleagues has ended 2 years ago, but my colleague still works as a judge because we still didn't receive applications for to replace us. Because the reason is that the member states don't cooperate with us with the applications. Some of the lists have been blocked because these bodies, these special committees, judiciary committees, said that the candidates don't meet the requirements. They refuted the list from Turkey, for example, from Azerbaijan and different countries. So there were not many colleagues who left the courts and were replaced immediately. With basically all the replacements, we had problems that the standards didn't that the standards were met. For example, Germany, the court told Germany that they didn't have a transparent election process for the candidates. Now that's a problem. If judges refute or tell countries that their processes are of the appointment of judges are unconstitutional, but then they themselves were elected in an unconstitutional way. Now, the ECTHR at the ECTHR there were a lot of former judges from the CJEU. They are very competent, of course, but the rulings of the ECTHR are not binding. So let me say one more sentence. At the CJEU, what is critical is the option of being re-elected. I think this is incompatible with everything we ask for in the name of the Venice Commission. We say that even temporary judges can be a problem, and if we have the possibility of judges being re-elected all the time, this is a problem we should think over. This is also what Poland said. Well, you have the same system, and then we said that we are structurally completely different as a European court, but actually, that is not true. Courts are courts, and the structure of courts is the same everywhere. Mr. Voskuhl, would you like to answer that? Yes, please. I'm sorry, I have to correct you. I'm not the president of the 255 Commission. I've just been a member of that committee for the longest time. This committee has a very important task. We are 7 people. And it's just difficult to find appropriate candidates in all the member states to work as judges in our established system. These qualifications are defined in our laws. They require a certain expertise. At the CJEU, that means that you need to be able to speak French and you need to be apt in European law. And we often have the problem that questions are asked to the candidates. Our commission assesses the candidates. And for example, we asked, can you tell us 3 important rulings of the CJEU from the last 10 years, and we don't get an answer. This is sad, of course, but this is a situation we come across very often. And it's not only candidates from new democracies, which we cannot accept. It's also, for example, candidates from Austria. Our requirements are very high, of course, and the candidates need expertise in international law, which cannot be taken for granted with judges from smaller countries, for example. We haven't had any situation yet where our recommendation wasn't taken into consideration. The court always respected our assessment, and I think that if the court wouldn't listen to us as a commission, we as members of the commission would leave it, because we think that our decisions should be binding. Now we also see a positive development. The appointment of candidates is more systematic in ever more countries. There is more transparency and more constitutionality in the process of the appointment of judges. So I think we could go towards such a solution to develop mutual standards. And these efforts, and we are pleased to see that the countries make these efforts. And when we see that a candidate has been appointed in a country where this candidate had to go through a systematic process, this lets us trust in that candidate. So what do you think about people, or what is there are also people who apply for the highest office in court who are not haven't been judges in their countries, but for example, state secretaries. They have, for example, successfully negotiated treaties for their small country, but they have no experience as judges. Do we want this kind of person to be judges, people to be judges at the CJEU or not? This is not something the Commission can decide. What we say is that people who want to be judges, they need to have 20 years of experience in a high-ranking post or profession, but not necessarily as a judge. So people who have worked as state secretary for 10 years, they have a completely different mentality and understanding of the law than people who have worked as judges. They have a different fundamental understanding of courts and the proceedings at the court. I think that this is something we need to discuss, and we need to establish a common understanding on what does a judge have to be like, and particularly on a European level. We need to ask ourselves, what kind of judges do we want? We need to develop criteria, which is of course difficult. Because even if you try to define independence and what the implementations of independence concretely are, so I think that's quite a complex question. Thank you very much, Mr. Voskuhle. Mr. Grimm, how would you answer these questions? And Ms. Nusberger and Mr. Voskuhle already gave you some keywords you could talk about. I actually don't have much to contribute because I was a member of an international court. I agree with Ms. Nusberger that the re-election of judges is a potential source of danger. So if a judge, for example, doesn't meet the expectations, you can just get rid of him in quite a short amount of time. Maybe I just didn't come across such cases, or I didn't see them, but I think that we need to pay attention to this fact. In the CJEU, there is a re-election process. And I think that they don't want to hear any different opinion, because then you can easily be attacked. Let me take the opportunity to touch upon another topic we need to discuss, I think. An international court needs to needs to treat all its member states equally and not differentiate between the good and the bad. So is this possible at all if the judiciaries in all the countries aren't equal? So if I treat everybody equally, but they are not the same, then I maybe strengthen these inequalities.
Ich denke, ein guter Punkt. Die Frage wäre noch.
That's a valuable point. Thank you very much. Now we talked about these two courts, the CGEU and ECTHR, and I already touched upon the idea that there could be a certain loss of trust, which is why they needed to implement a judiciary committee. But on the other hand, we have the Lisbon Treaty, where there is also an improvement when it comes to the appointment of judges. Can you also say something about Karlsruhe and the German Federal Constitutional Court? Because that's also a court which is widely known and respected. Its representatives are respected beyond the borders of Germany. Here in Switzerland, we also read the rulings of Karlsruhe with great interest. So maybe something works better in Karlsruhe or in Germany than in other countries or on the level of the EU. So maybe you can touch upon that question as well, particularly when it comes to the appointment of judges in Karlsruhe. I think we can boast something about that, Mr. Grimm and I.
Einmal den großen Vorteil in dem Verfahren, dass wir eine Zweidrittelmehrheit brauchen.
So what is an advantage in our process is that we need a 2/3 majority in the parliament. So we need to elect candidates which are likable by all the parties. So let's say people with extreme positions don't stand a chance to be elected as a judge. So this is one advantage. And the second important advantage, I only understood when I started to be a member of the court. So why is Karlsruhe not yet involved in politics? Because being a judge there is a very lucrative office. So why don't the parties put judges into our highest court? So why is every judge in Karlsruhe highly qualified? Today, this is Mr. Habert, Mr. Müller. They are outstanding jurists, outstanding lawyers. The reason is that if you are a member of the court in Karlsruhe, you need to work in Karlsruhe. So if you don't know anything about law, you have to work alone there. People will know directly that you know anything about it, because if there is a ruling, if something is in question, people will ask, don't you know the ruling of this and this year and this section? And if people don't know it, the audience immediately knows that they're not qualified. So we pass the rulings alone. We do the consultations alone. So therefore the offices of the judges are unattractive to people who just want to have a prestigious office, because they actually need to do the judiciary work. Second, there is a pressure in the court to be independent and to not rule in a political way.
Ich sage es mal ganz vorsichtig, etwas leistungsschwächer sind als andere, sich aber trotzdem sehr
people who do not perform as well as others are very diligent, which also leads to the fact that quality is high. But we also have our problems in Karlsruhe, and one of them is always also, so what we need, what our problem is that we don't have a representative cast of the board of judges. For example, we needed to replace a judge, and the replacement judge needed to be from the east of the country, and we decided to take a candidate which was not the favorite, but she was from the east of the country, from eastern Germany. So what about the representation of other bodies? What about the churches? If we don't talk only about women and men and East and West, but also about churches, other groups, I think that the courts should independently pass their verdicts and rulings, and they shouldn't be just boards which represent all the population. So I think that this is a problem and a danger that our highest courts, that the quality of our highest courts degenerates because we cannot appoint the most capable people to these posts, but that we always need to consider representation, which means that the quality degenerates. And I think that's a difficult problem.
Thomas, would you like to ask a question? No, an administrational comment. If you have any questions, do not use the chat function, use the F&A function. And another remark. Anne Sanders is with us. And during the second part of today's conference, well, she will give her lecture, but she has already joined the group. Sanders is professor at the University of Bielefeld. She has worked with the CCGA, the Consultative Council of European Judges, and I wanted to welcome her. We talked about the different courts, the lower courts, the highest Supreme Courts. But during the three previous talks, we talked about their roles. The Venice Commission has a consulting role. It is to give advice, but it depends on the state's willingness to do good. Mr. Voskuhle, you said that the ECJ is taking a look at the systemic framework, that it has given itself the competence, and Mr. Grimm, you said that the ECTHR is not yet doing this. Now, I would like to ask you, all the four of you, what would have to happen for the ECTHR to stop that? Why am I asking this? I'm under the impression, well, you can tell yes or no, but I'm under the impression that it works better in the European Union because it has certain standards. And outside of the European Union, Russia, Turkey, it doesn't work at all. Who would like to start? Who can answer this question? Well, I would like to start. Let's take a look at the scale, national state and European Union. It's being changed quantitatively. It's a single state, and then we have 47 on the level of the Council of Europe. So there are always different levels, and it is, of course, much more difficult for 47 states to not only compromise on concrete measures or assess the situation, to first assess it on a member-specific, country-specific level, and then extrapolate it to a comprehensive solution. It is, of course, difficult, and one needs to bear this in mind, but still, they need to tackle this. You might not be able to solve the problem on the highest level. It is a step-by-step approach, level by level. And it's difficult to systemize it. But let's say we were able to assess or embed a context or a situation with 7 or 8 variables into a joint context. That would be great. That would be quite some progress. Ms. Nusberger has an internal view. I have an external view, so maybe she could be the right person, or she is the right person to answer that question. Of course. First, I would like to explain how this has grown in Strasbourg. There are different chambers, and it has become an urgent problem. The ECTHR and the ECJ don't have a good initial instrument. Why? Well, I mean, we heard about that at Mr. Voskuhle's presentation. Article 19 wasn't meant like that, but they said, okay, we don't have an instrument that is better than Article 19. And it comes with a dogmatic problem, to say the least. The ECTHR also has a dogmatic problem because it deals with cases like these in a twofold way, and sometimes it works quite well in terms of protection. The citizen says, I stand before an independent court, but how can we prove that? And then we end up with all these criteria that you were referring to, and it's very difficult to explain all that. And then there are exceptions, the Turkish military courts, you name it. And we try to end up with objective criteria, and then there are deficits in courts, and we see that once judges are removed. And if this situation is brought to court, then this case ends up with judges. So you don't have a subjective right to independence. It is an objective right. And the court in Strasbourg really tried to construct it around the corners, so to speak, with Buckhart, for instance, where the president was not, his term of office was not expanded. It was the president at the Hungarian Supreme Court. And he started working on the freedom of opinion. That was the initial point. The Article 6 topic was a topic on the fringes, and that was the big problem. The ECTHR tries to control these situations via Article 8. And then we have the Polish judges trying to fight this, and they're being sanctioned. They say they are removed. It is an interference with their private life. But we do not have the occupational freedom. And these cases will make us a court, the Supreme Court of labor termination. So it's a problem to be able to use that and take it to the Court of Human Rights with a link to labor and employment. So the basic construction is difficult. If I may chime in, let me ask the following question. In the beginning of the ECTHR, we had state complaints and then individual complaints. And we have seen over time that it does not work well because the states see another state's complaint as an attack. So we have the High Commissioner for Human Rights, or maybe a body like this. They need to be able to file a complaint when it is about a systemic problem. Ms. Sanders, would you like to say something? Sure. What Ms. Nusberger just said is central. The courts are institutions
da sind und nicht dazu da sind, institutionelle Garantien durchzusetzen. Das ist eigentlich etwas, was Gerichten eigentlich nicht zukommt, was sie aber zunehmend, was man ihnen zunehmend zuweist, sowohl national, zum Beispiel in Bezug auf ökologische Fragen, nicht sozusagen der Individualanspruch auf den Klimaschutz und solche Sachen und eben international institutioneller Anspruch auf Rechtsstaatlichkeit. Und das ist eine sehr spannende Entwicklung und da müssen wir uns natürlich auch bewusst sein, dass das auch ihre Risiken birgt gewissermaßen. Insofern wäre es eigentlich sinnvoller, sich zu überlegen, wäre nicht sowas wie der Hochkommissar Staatenbeschwerden, sowas eigentlich die besseren Ausgangspunkte und auch Institutionen, die das, was Herr Grimm eben auch als kulturelle Frage, Rechtsstaatskultur, Kultur der Unabhängigkeit, habe ich das mal genannt, bezeichnet, dass man da größere Blicke nehmen könnte, eben sagen könnte, in welchem Kontext steht das alles. Beim EGMR war mein Eindruck, wenn ich mit ihm im Zusammenhang mit dem CCJE zu tun hatte, in Diskussionsrunden, durchaus der Eindruck, dass viele der Richter sehr, sehr aktiv darüber nachdenken, wie man zum Beispiel Artikel 6 individueller auslegen kann. Aber die Frage ist natürlich wirklich, wollen wir das und ist das der richtige Weg dieser Gerichte? Und entspricht das dann unserem Richterbild, um darauf noch zurückzukommen, dass der Richter im Grunde eigentlich nicht auf den Einzelfall schaut, sondern notwendigerweise auf die institutionellen Zusammenhänge.
Ja, auch hier. Ja, Herr Voskuhle, bitte sehr.
Ja, also ich möchte das sehr unterstreichen, was Frau Sanders gesagt hat.
I would like to highlight what Ms. Sanders just said. We all want to help. We're observing what's happening in Hungary and Poland, but their options are limited. Let's take a look at the ECJ situation. We have two trials. Now, single judges, maybe they're even affected themselves, they need to try to develop international standards and present them in their own state. This is very difficult. And sometimes they have to fear sanctions, maybe within the framework of an arrest warrant. If you expect of the court to rightly assess the situation in another country with all its complexities, then this is really what an institution can do. It's very, very difficult. And a procedure of monitoring a state's rule of law is not the right procedure. The Commission has more options, more opportunities, but we need a very detailed analysis of the links and connections, and it leads to a situation where the judicial penetration isn't very precise. It's an overall analysis, open to interpretation. Maybe this monitoring mechanism to supervise the rule of law is good. The Article 7 proceeding is the right one. You would have to have different majorities, or maybe you could think of different institutions. Ms. Sanders referred to that. So you can exert political pressure, and you can discuss these issues from a political perspective. the infringement proceeding could be decoupled from financial means, but maybe this is much more helpful to have this link than with sorting to the judiciary. But if you couple it to a subjective claim of an individual, it brings us to a situation where political questions need to be decided upon by judges, and this will lead to a problem of acceptance. Mr. Grimm? I second that strongly. What we are seeing right now in connection with the ECJ's jurisdiction is that it gets praise, but the European Union doesn't have effective tools to make sure that the member states observe their own rules and regulations, and then they open a door and they are applauded. It's not doable in institutions, but it's now doable in courts. And it's not only a question of formality. We have the separation of powers. That's also the title of today's conference. We have the separation of powers for a reason. The three powers are separated. And I believe in the long term, the damage is harsh. It's quite big. Well, time is of the essence. It's 5 to 3. And there are so many questions coming in. I don't know what question to pick. I do not want to decide which question to take. It would be done arbitrarily, but there are questions or my question to you, that if you could make some general remarks. There is a discrimination between ECJ and the court in Strasbourg. It only has a fraction of the financial means the ECJ has. Ms. Nusberger referred to a case in Albania. What about their budget-related financial structures? Shouldn't they play a role so that they can see to it that judges are independent? That's one thing, budget, financial links, and concrete interference by the executive. I'm sure you know what Lucius Willhaber told us, the former president of the court in Strasbourg. He told us about the ambassadors that paid him a visit, and they were trying to exert influence. So that's an example of concrete interference by the executive. Another block of questions could be about standards for re-election, if there is a possibility of re-election, like we have in Switzerland. What could be a standard developed by Strasbourg or Luxembourg? And in what way could the Commission's opinions be included? And a last question that affects us a lot in Switzerland is a question pertaining to political party affiliation. Political parties have a recruitment mandate, basically, but it comes with a recruitment responsibility. When we were enrolled at university, it was different, and things have evolved, of course. 7% of the Swiss population is enrolled in a political party nowadays. Maybe I start with Ms. Nusberger, maybe some final words, and you can pick the question now. Maybe you can start. We do not have a lot of time left, I'm afraid. So maybe one phrase per question. As to the recruitment process in Switzerland, well, the European understanding is different. I've always known the reactions when I explained the recruitment processes to the Constitutional Court in Karlsruhe. They told us, no, we had never been a member of a political party, so it's the opposite, basically. And in the East European countries, it's different too, and we can understand where their understanding comes from. As to financial means, yeah, the court in Strasbourg is poor, same for the court in Luxembourg. And I don't believe that they will receive more financial means. The countries to criticize that are the ones that do not want to invest more. So I, throw my head to the registry. They have only some means, but they make the most of it. As to the question concerning to re-election and standards, re-election shouldn't be possible. It was abolished at the ECTHR for this exact reason. And, well, as to the last point, concrete interference by the executive. I have never seen that, but let me say the following. There is an indirect interference, which is quite problematic, and we have to deal with that. Let me take Switzerland as an example. You know that there was a referendum in Switzerland, I believe it was 2 years ago. And it would have led to a situation where Switzerland dropped out of the ECTHR. It was about the last word being with the judge. And if you make rulings, does that mean that the state affected can step on the brake? And the judges who basically read the paper and they know what's at stake, they could, I say they could be pressurized. They could be put under pressure. But it's much more, well, the indirect interference is much more central.
Hinter der Frage der Parteilichkeit.
When it comes to the question of the membership of parties, we need to answer a larger question. Judges are part of the state power, and in a democracy, they need a democratic legitimation. And if they're not democratically legitimized by people's votes, which I do not support, let's have a look at the US, and you understand what I mean. You need to have money to finance your campaign, your pre-election campaign, and so on. So if you don't want to legitimize yourself by the people, which I don't think is necessarily good for the office of a judge, then we need to take the legitimation for somewhere else. And we can then almost only legitimize ourselves by people who have themselves been legitimized by the people, which is the parliament. So we can't really get around the political parties. And even if we establish intermediary bodies which are impartial by appearance, they are not so impartial at a closer look. So I think that we just need to deal with that people belong to a party, or judges belong to parties. I don't think that it is helpful if we forbid the judges to be part of a party, because it doesn't necessarily mean that they represent certain values and that they judge according and in alignment with these values. I think that this is most important, that that the party values don't influence the judges' rulings. Now, I think we get back to the legal culture of a country. The Federal Constitutional Court is legitimized by the legislative, and the two-thirds majority in Germany led to the fact so far that there is in total a high neutrality of the Judiciary Board in Karlsruhe. And I don't know why it's not different, because usually if we have a supermajority that elect a body, it is usually the case that parties tell each other, you accept my candidate and I accept your candidate. But that was never the case. The political parties agreed upon the candidates. And they often use the means of a veto. But the public doesn't know that, because these sessions are held behind closed doors. Well, I'm not sure whether we should open the doors and whether that would lead to better or rather worse results. Thank you very much, Mr. Grimm. Mr. Voskuhle, you have the floor. Thank you very much. Mr. Grimm said everything I wanted to say about party membership, so I don't have to repeat this. Thank you very much, Mr. Grimm, that you said it so clearly. So we can't avoid the parties, and that is not bad, because they are also a form of democratic legitimization. What I consider central is that judges cannot be re-elected. I second Ms. Nusberger's opinion there. I think that's a very difficult situation, because for the person, this is about her or his status, about the social standing. They depend from, so they want to be re-elected, and then they do what is necessary. So if you imagine that somebody from Romania, where a judge earned about 1,000 euros, and in Strasbourg you earn 22,000 without taxes, it is clear that you want to continue that mandate, and I think we need to change the system here. We also need to give another thing a thought. When it comes to internal positions like the president, it means that if we do official elections there internally, then you need to do a pre-election campaign and so on, and you have to form a group of supporting judges. So I don't think that this is a very healthy procedure. So we need to have a closer look at our and the international courts and make sure that they are financially well off. They have to be financially secured, and the judges too. If a judge, terminates his or her term in office, they need to have the option of receiving a pension, because otherwise he will slide into a new dependence. And I think that is quite problematic at the two international courts we are talking about. So a person who stops working as a judge in one of the courts has nothing when he terminates his term in office, and needs to find something new how to earn money. So we worked out some solutions in our commission. And we underline that the salaries of judges shouldn't go beyond a certain point and that they are essential to our proceedings. Last thing I would like to say when it comes to interference, when we talk about actual court proceedings, then courts are more resilient than we might think. It's the indirect interference at the beginning and in the end, which are the point of danger but we never get phone calls where people say, could you please pass your ruling in this or that way? I think that this happens less often than you would say. When I was a judge, I never came across such a situation and nobody ever told me such a story. The problems are at the beginning. Who gets access to the court? And at the end, can I stay? What will I do afterwards? And so on. So I think this is where we need to put our focus. Also, when it goes about when we talk about freedom of instructions, then we don't really have this problem in Germany because there will always be a political fuss about such a case, and that would be dangerous for example, a politician who wants to influence a judge. I don't think that this is where our problem actually is. There are countries which might deal with that problem, but I don't think that we should focus on that in our discussion at the moment. Thank you very much. Thank you very much, Mr. Voskuhle. We have still some time left for Ms. Sanders. So we can just grab a coffee afterwards and take it back and drink it in front of the screen. So we do have a bit of time for Mrs. Sanders. So, what I consider important is that there should be no re-election. I think that is a central point. Also for the prestige of the Federal Constitutional Court. I think that is central to the Federal Constitutional Court in Germany, that there is no re-election and that the judges always know what they will do afterwards. So they can pass their rulings freely and independently. Financing is another point I would like to touch upon. If we want an independent judiciary, we need to finance them well, because if the buildings degenerate, if a judge doesn't know how to feed his or her family, it is clear that the judiciary can't be independent. And we see in other countries that the judiciary is very badly financed, which leads to grievances. The legitimation by the sovereign, the people, is very important for Switzerland, and I think we will touch upon that in the second part. Thank you very much, Ms. Sanders. So we come to the conclusion of the first part of our conference, the European part. Like in a good seminar in Switzerland, I would say that the best seminars are the ones where we as lecturers learn the most. And I think it was a fantastical round. I learned a lot. It was very interesting. And it was impressive what we heard from you. I think in the second round, in the Swiss part, we're going to keep all what you said in mind. Thank you very much. I think we were able to answer some questions, not all of the questions. I also have some questions left, but I think that I'm sure that we will have a second conference of the kind, and we'll maybe touch upon these questions the next time. So now we have 15 minutes break, and we will find ourselves here again. Mr. Stadelmann will host that second part about Switzerland. Enjoy your coffee. Thank you very much.
Wir haben 3:30 und kommen zum zweiten Block.
So it's 3:30 and we start with the second block, judicial independence and separation of powers in Switzerland. Where do we stand in Switzerland? So I'll proceed in the same way as Mr. Breitenmoser. I won't introduce the speakers to you because I think that you know almost all of them. Professor Dr. Ulrich Meyer, the floor is going to be yours. Until last year, he was the president of the Swiss Federal Supreme Court. Ulrich, I pass the floor to you. Dear colleagues from near and far away, ladies and gentlemen, Swiss Judiciary.
Auf den Umstand verstellen,
this term should not delude us from the fact that the legal system in Switzerland is very federalistic. In our federal state, the cantons are to a very large extent responsible for the judiciary and the court organization. They very much want to keep this competence. In numbers, this has the following implementation. The Federal Constitutional Court has about 8,000 cases it deals with a year, but the cantons deal with several 100,000 cases per year. The organization of the courts is very differently regulated in the different cantons. Many of the cantons have a so-called parliamentary election and re-election of the judges, but there are also the popular votes or popular elections. On the second Sunday of my colleague, Mr. Nussbaum, was elected judge of the Federal Constitutional Court following a suggestion of a colleague. So let me tell all of the participants from other countries, I invite you to visit our community in the small canton of Glarus. So if we talk about the need for reform of the courts on a federal level, this does not necessarily reflect the status in the cantons. Some of the cantons are pretty much further are more developed when it comes to the procedure of the election of courts. Now let's talk about the difference between appearance and reality. Our constitution defines the Federal Supreme Court as the highest court, the Supreme Court of our country. However, in practice, the legislation is okay with the fact that everywhere, practically every case in every part of the law can be brought to the Federal Supreme Court. We dealt with 8,000 cases last year. No matter how small a matter is, if we talk about 100 francs a person has to pay for a breach of a law, we need to deal with that in the end. This is the real problem of the federal court. It's not about who is admitted as a judge. In our country, we still think that the Federal Supreme Court exclusively is able to protect people in terms of law. This stems from a time when the cantons weren't yet part of the federal judiciary. The European Court for Human Rights said to Switzerland that even if a judge, a police judge passes a verdict, it has to be examined by a judge. But actually, we shouldn't have to decide in individual cases. This is this is what actually the lower instances do. This is actually what I wanted to do exclusively when I was young. I didn't want to become a Supreme Court judge. So what the Supreme Court does is to control the legislation and to answer fundamental questions of the legislation. But the people want something different, and the parliament wants something different. Now, the high work overload we have is because the Supreme Court is treated as a court of third or second appeal. And then we have a mass production of verdicts. Now, this impedes what we actually have to do. We have to answer judicial questions, and we have to judge about fundamental judicial question, legal questions. But we cannot do this unrestrictedly. So because we have this work overload of minor and not unnecessary cases, we cannot do what we actually should do. So what we need is a different system of which cases are actually admitted to this to our court. So what we can say, what is a positive aspect maybe, is that since we have to occupy ourselves with these minor cases, politics can't possibly influence our work. There is just no room for it. I know because of my contacts to different countries I had as a federal judge, our system is full of contradictions, and still it works in practice. The Judicial Commission, United Parliamentary Assembly, elects the federal judges according to the parties, the distribution of the parties in parliament. And then we have a re-election after 6 years, and during their term in office, the judges usually belong to a political party as a rule. However, the ethical guidelines demand that judges restrict themselves when it comes to activities for their parties. And the judges pay mandate taxes to their parties. All of this, and of course also that there is no disciplinary legislation, this is not understandable from the outside. When I was visited by the Groupe d'État contre la Corruption, GRECO, on the 1st of June 2016, I tried to explain to them, but obviously in vain, that these mandate taxes are not only paid by judges, but everybody who bears an official office in the legislative, the executive, and who is a director or member of parliament. it is nothing else than a typical Swiss substitute for the fact that we don't have an official party financing. And furthermore, I told the people from Greco, and this is a very important thought Mr. Grimm touched upon too, independence of the judges through respect by the first two branches of power towards the third doesn't depend on the law and the legislation. It's a question about the legal culture. It's about the head and the hearts of the people who reign our country, who rule our country. What is more, it is also a question of the trust of the people in the courts. Trust and respect of the courts is what is most important, what is the basis we absolutely need to be concerned with. After working 40 years for the Federal Supreme Court, I can confirm that we are politically elected, but we do not pass political verdicts. Although we know that our verdicts or our rulings can have political implementations. And this system still works. Every judge, with no exception, work to their best knowledge. So when we look at the judicial bodies, usually the rulings or the opinions don't reflect party values. We don't even have even have secret deliberations, which is also very strange if people look at it from the outside. Now, if we look at how people are elected, it's very easy. If you want to stand as a candidate, you write a letter to the commission, the Judicial Commission in Bern. You include a curriculum vitae and so on. The Judicial Commission is a joint commission of the parliament. So it's a commission of the United National Assembly. Then we have a subcommission which does a pre-election and looks at references. Then they decide, then the Judicial Commission decides whom they want to suggest the Federal Assembly as a candidate. Then it goes to the political fractions, and afterwards they make their statements, and the Commission then decides definitely who is going to be a judge. The United Assembly has always followed the suggestions of the Judicial Committee so far. According to Article 28, paragraph 3 of the regulation of the Federal Supreme Court, the Supreme Court looks at whether they can replace a judge internally. And then it tells the result to the Judicial Commission. We can, of course, improve that process. And what I also would suggest is that when the Judicial Commission receives the candidatures, the applications, that they talk about it with the Supreme Court, because I think that it would be more transparent than the actual procedure of finding references and deciding. The Canton of Bern has introduced such a procedure, and it has proven its ground. So if it talks its suggestions over with the federal court, this is nothing about self-cooptation. The Judicial Commission would still be independent in what they eventually suggest to the United Federal Assembly. So this would be a minor change which would significantly improve the process. It is not necessary to have an expert commission as the judiciary initiative wants. After talking it over with scientific representatives and the parliament, representatives of the parliament, that wouldn't be helpful at all. On the contrary. Fifth, re-election. We already talked about re-elections in the first part of our conference. Why do we have these re-elections? In 1848 and 1873, when our first constitutions were written, it was included there that the sovereign or the parliament elects all the office bearers, including the judges of the Supreme Court. At that time, the judges were re-elected every 3 years when at the beginning of every new legislative period. These re-elections were undisputed, and this is why the parliament prolonged the official term of office to 6 years. So this 6 years term of office has a prosaic historical reason. So judges are re-elected every 6 years, and it has never been questioned so far. And of course, the reason for that is that there is a lack of separation of powers in this point. It is based on the principle that every state organ needs to be democratically legitimized, including the Federal Supreme Court. There was a ruling in 1996 about whether crucifixes should be part of classrooms in Ticino. And there was a case that after this ruling, those who didn't oppose this ruling were re-elected with worse results than their colleagues. So since then, we know that problem. Is it legally okay to use the re-election as an instrument to sanction judges because they made a ruling which didn't please a party or a person? Of course not. And here I come back to the legal cultural mindset. So the system still works. On the 23rd of September 2020, all the judges were re-elected with better results than 6 years before, although there was a very much disputed ruling in the summer of 2019. This ruling was publicly very heavily criticized, and still the re-elections went well. So I think that the re-elections process and system of federal Supreme Courts have proven their ground and work well. So this system works. And it works as long as the political power is diverted between the parties. I already come to my conclusion. I'm not exceeding my time as a good Swiss person. As a conclusion, I can say that the rule of law works in Switzerland. The federal court is independent and the federal judges pass their judgments completely independently. Secondly, the judicial administration doesn't need any other system of election than the one which is in place now. But we could include the Federal Supreme Court in the admission process of new judges. What we need is a structural reform on the level of the Constitution and the laws, which allows the Federal Supreme Court to concentrate on its core task as a Supreme Court of the country. This is what we need to do. Thank you for your attention.
Thank you so much for your speech. You have proven that you are independent, at least when it comes to the internal relationship, saying re-election is not possible, and you have found it's a watertight process. Thank you so much. Without any further ado, I would like to continue with our agenda. Switzerland, Problems in Switzerland from a European Perspective is the title of our next talk. Ms. Sanders, the floor is yours. Still muted. Sorry. For all the differences between legal systems, judicial independence is the basis of the separation of powers and cooperation within Europe. Judicial independence is not a privilege of judges, but a prerequisite for courts to be able to perform the social task of settling disputes. After all, why should the disputing parties go to court if they already know how the judges will decide the case? Establishing judicial independence is much more difficult for a legal system than establishing a court, because at the core of judicial independence is ultimately an inner attitude. It is the attitude you see in this picture, where Polish judges are holding out the Constitution of the Republic of Poland to the Ministry of Justice. But you cannot see this inner attitude on someone's face before things get tough. And it is certainly a good thing that female judges don't have to be such heroes, heroines, fighting for the rule of law everywhere. To quote Bertolt Brecht, it is not the country that has no heroes that is unhappy, but the country that needs heroes that is unhappy. Standards of judicial independence therefore create at best frameworks within which judicial independence can flourish without heroism. Because it is precisely the attitude of an individual judge that can be difficult to determine, it is central to avoid not only the exertion of pressure, but by other powers on the judiciary, but also the mere appearance of such influence. Pioneering Swiss scholars such as Regina Kiener have already pointed this out. The European institutions want to create standards for such frameworks in which a good appearance can exist. The main players of judicial independence in Europe have already been presented: the ECJ, the ECTHR, and the Venice Commission. I would also like to mention the work of GRECO, Group of States Against Corruption, and the CCJE. The CCJE, the Consultative Council of European Judges, is also a body of the Council of Europe. Its members are judges from all member states. Its main task is the annual preparation of opinions, recommendations on various issues closely related to judicial independence and the organization of the judiciary. Looking at the judgments of the ECTHR and the ECJ and the work of the Venice Commission, as well as GRECO and CCJE, 4 fields can be identified with regard to Switzerland that require closer attention. First, political election and re-election after a short term of office. Second, the so-called mandate tax. 3, disciplinary proceedings. And 4, education and further vocational training of judges. All of these issues are ultimately about the conflict between 2 images of judges. European standards assume a professional, well-trained judge as part of the third power, the judiciary exercising their office for life as independent as possible from politics. The Swiss conception of judges, on the other hand, seems to see judges more as politically integrated mandate holders who, like parliamentarians, have to be legitimized by the people every few years in an election. In connection with Switzerland, Fabian Wittrek spoke of a traditional high evaluation of the democratic legitimacy of the third power compared to its independence. However, the discussion within Switzerland in recent decades shows a tendency towards more professionalization and emancipation of the third power from politics. This tension between tradition and emancipation is reflected in the questions to be discussed here. Firstly, political election and re-election. The appointment of judges is a central theme of all the European institutions which we have already mentioned, including the Council of Ministers of the Council of Europe. All decisions concerning the appointment or promotion of judges should be based on objective criteria determined in advance, looking at the performance, qualifications, and skills required to apply the law with respect for human dignity. According to the Council of Ministers, the institution that makes the selection should be politically independent of the legislative and executive branches. The Venice Commission also emphasizes in the 2016 Rule of Law Checklist, we talked about it before, it emphasizes that the selection of judges should not be based on personal or political criteria, and that any system of selecting judges should be consistently reviewed to see if this is the case. Appointment by a parliament is viewed critically by both the Venice Commission and the CCJE. Both institutions fear that political points of view and instead of performance and abilities of the candidates will be the deciding factor. It is recommended that decisions be made by an independent institution, for instance, a council of judges, at least half of which should consist of judges elected by their peers. However, such judicial councils as they exist in many countries cannot and should not be viewed uncritically. The Venice Commission and the CCJA also point out that politicization and nepotism must be prevented in such institutions. In Switzerland, politics and the judiciary are closely linked when it comes to the selection process of judges. They are legitimized by an election by parliament and the people for a kind of legislative period. They are not civil servants elected for life. The tension with European standards is clear. In the fourth round evaluation in 2016, Greco recommended that Switzerland place greater emphasis on quality and objectivity in the recruitment of female judges. The most competent judges should be selected, and not those with the best networking skills. In addition, non-re-election should not be based on the judges' decisions, and the re-election process as a whole should be scrutinized. From a European perspective, the Swiss practice is particularly alarming in that persons who do not belong to any political party are practically excluded from being appointed. I observed this myself when interviewing judges and court clerks in various Swiss courts. The clerks repeatedly said that they would like to become judges themselves, but that they were afraid of being too close to a political party, which is necessary for election, and that may be uncomfortable, especially for younger people. However, a complete isolation and separation of the three powers during the appointment process is difficult to demand in light of European standards. Their personal networks will probably always play a role in such decisions, and in Switzerland, without any doubt, very competent female judges are elected too. Both the Venice Commission and the CCJE, but especially the ECTHR and the ECJ, are aware of the different European traditions. Thus, the ECJ also declares the mere fact that the legislative or executive branches intervene in the process of appointing a judge does not create a dependency of that judge towards those branches. Neither does it raise doubts about their impartiality if the person concerned is not subject to any pressure after their appointment and is not subject to any instructions in the exercise of their office. From a European perspective, the relatively short terms of office and the re-election process in Swiss courts is, to me, more critical than the political elections in Switzerland. I am aware that the short terms of office, which resemble legislative periods, are consistent with the judge's image of office holders who must always be democratically legitimized anew. But the tension with European standards is particularly strong. Re-elections are viewed critically by the Venice Commission and CCJE because they can make judges dependent on the institution responsible for re-election. Re-election highlights how important it is for the institutions electing the judges to be completely independent. The Venice Commission strongly recommends that judges should normally be appointed until retirement age. For constitutional courts, shorter terms of office could also be considered, but better without the option of re-election. The ECJ mentions tenure as an important factor of judicial independence, although legislation does not yet go into detail in this respect. As I understand it, re-election by Parliament, especially after a rather short term of 6 years, may well give the impression that judges are politically dependent. Saying that judges have always been re-elected does not help to refute this objection, apart from an operational accident, so to speak, when Federal Judge Schubart was to be given a lesson and too many parliamentarians removed him from the list. If re-election is a formality, it can be dispensed with. The very fact that individual parties call in judges and given a lesson by voting in a specific way shows that re-election is not a mere formality. If this is intended to enable Parliament to express popular anger about politically unpopular decisions, well, to teach them a lesson and, if necessary, to refuse to re-elect them, then this must give the impression of dependence, even if, as I assume, judges have their inner strength not to let themselves be influenced by this. Even if, as I'm convinced, the system has traditionally worked in this particular Swiss party system, such barriers can easily crumble in an increasingly polarizing political world. This is true not only in Switzerland, but also with regard to election procedures for the highest judicial offices in Germany. Now I'd like to talk about the mandate text. The mandate text, it was just explained, is a special feature that regularly causes incomprehension among my students when comparing this to other systems. Greco apparently felt similarly. In the fourth evaluation round in 2016, a repeal of the party text was recommended. The Swiss reaction expressed some understanding, but could not bring itself to abolish it altogether. In any case, since the mandate text, which is known from parliaments, is unique to judges, there are no general European standards that deal directly with it. However, in my opinion, it violates the basic European principles outlined above, according to which the impression of pressure and dependence on the other powers must be avoided. Even though Swiss judges repeatedly emphasize that this tax is voluntary, but one might get the impression that the tax is supposed to be a quid pro quo for the previous election and future re-election, even if this is actually not the case. Third point, disciplinary proceedings. They're important to ensure that judges can be held accountable for unlawful conduct in a legally secure process. In its opinion number 18 on the judiciary in a power-sharing state, the CCJE referred to this as punitive accountability. The European institutions of the Council of Europe agrees that the disciplinary proceedings should be conducted by an independent body or tribunal. The principles of a fair trial are to be observed, and the possibility of an appeal is to be granted afterwards. The CCJE states that members of the executive and legislative branches of government should explicitly not adjudicate disciplinary cases. The conditions for disciplinary responsibilities must be clearly defined in advance, and the decision must be clearly justified and proportionate. Corresponding disciplinary procedures do only seldom exist in Switzerland. In a system in which the office of judge must legitimize itself through election not only at the beginning of the career but again and again, it stands to reason that the task of the disciplinary procedure would be assumed in the decision to grant or deny re-election. But a re-election process has an entirely different thrust. Re-elections to parliaments are necessarily granted or denied for political reasons. Refusal of re-election is not a sanction because, strictly speaking, there is no right to re-election. Fourth point, training. The discussion about election and re-election, mandate text, and disciplinary procedure demands a definition of the position of the judiciary either as elected and politically integrated office holders or as a professional group of the third power of the state that is to be seen separately from the field of politics as it corresponds to the understanding of the European institutions. Judicial education and further vocational training is an essential part of such a professionalized understanding of judges. Accordingly, both recommendations of the Council of Ministers of the Council of Europe and the CCJE see training and further vocational education as a right and duty of judges. Such training should be financed by the state and organized independently. In Switzerland, there are offers of the Judicial Academy, the RIAK. A minority of cantons require attendance at the Judicial Academy in the run-up to an election or after an election. In some cantons, attendance increases the chances of election. This underlines the growing importance of training and showcases the ongoing professionalization of the Swiss judiciary. It is an important offer that must be strengthened and supported. This brief overview shows that there are areas of tension between the traditional Swiss understanding of the judiciary and the standards of European institutions. In most cases, it is a matter of soft law. Direct consequences are therefore not to be expected. Why then, with a view to such standards, should one question concepts with a long tradition that have always worked in the past? Germany, too, has never followed the recommendation to establish a judicial council. And both the Swiss and the German judiciary enjoy a good reputation. So can we leave it at that? Are such standards ultimately of any use at all? In recent years, we have seen judicial independence crumble, especially in Central European countries. There are extensive safeguards for judicial independence in their constitutions. Laws have been abolished, safeguards eroded, appointed judges are removed, despite everything. One might ask, and I have asked myself this again and again in recent years, how effective standards, indeed even written law, actually are against determined politics. Is the text of a constitution ultimately no more than a line drawn on the ground with chalk to make political forces believe that there is a wall? Even constitutional courts depend on the cooperation of the other powers and the trust of the people to enforce their decisions. If such standards do not reside in people's hearts, then not a single constitution can permanently keep such political forces under control. Especially in the so-called established democracies of Western Europe, the protection of independence is often based less on elaborate constitutional texts and institutions than on traditions and customs of political players, such as the Swiss understanding that judges are re-elected no matter what decisions they take. I once called this a culture of independence. Is this not enough to protect judicial independence? I don't think so. We need both inner conviction and institutions that uphold standards as a framework, just as a good judge needs inner conviction and yet must avoid putting on a bad appearance. We need the heroic spirit without having to fight every day. This brings us back to the beginning of our considerations. Independence is an inner attitude, a matter of character. One cannot look into judges. But as a society, we do not tell the subjects of law to believe in inner independence. This requires framework conditions within which a good appearance can be developed. International standards are intended to set standards of good conduct across borders because the political culture of a country is just as difficult to measure from the outside as the inner attitude of a judge. They create the international public sphere that helps protect judicial independence across borders. Judicial independence becomes invisible where it is being attacked, either socially when judges have to heroically prove their independence or when the culture of independence has not been sufficient. References to the political culture of a particular country carry the danger of false security. It's okay with us because it's tradition here, but not in other countries. Of course, it is different whether something has always been that way, let's say in Switzerland or Germany, or whether it is being changed to make the judiciary compliant. But the barriers of political and cultural customs can also change. Unfortunately, so can ours. And in an ever more polarizing world, they can change faster than you think. Thank you for listening.
Vielen Dank, liebe Anne. Du hast einige Punkte aufgezählt, wo Änderungsbedarf bestehen könnte in der Schweiz. Und
Thank you very much, Anne. You named us a few points where we could improve in the Swiss system. So we are going to listen to two speeches on possible changes. Mr. Adrian Gasser is going to talk about appointment of judges by qualified lot. He is the founding father of the initiative, the Judiciary Initiative from Switzerland. The floor is yours. If I had to design a new state order from scratch, I wouldn't change much in today's system. What would be important for me is a working separation of powers with a truly independent judiciary. And here in Switzerland, this is what we lack today. The judiciary is intertwined manifold with the legislative and the executive. There are obvious problems resulting from that. The litigants don't believe in the fairness of the judiciary, which results in people criticizing and mistrusting the rulings. The judiciary is perceived as an extended arm of politics and authorities, and the litigant it's not possible for a litigant in today's system to trust in the rulings, which is actually a basic necessity for a democracy. Because it's the political parties alone which decides who is going to be a judge at the highest federal court. However, we have a lot of rulings which are respected by the litigants because they correspond to the law and the sense of justice. This is the case not because of the system, but no matter the system, despite the system. Now, our highest judge's entanglement with and dependence from parties and politics is one of the reasons why we were able to collect more than 130,000 signatures in no time for our initiatives, although the initiative was never covered by state radio or TV. What does it root back to? This system, today's system, which doesn't meet the requirements of the litigants. The system goes back to the foundation of the federal state in 1848. At the time, the federal court was part of the Justice and Police Department, and the tasks of the Federal Supreme Court were limited to insurance matters and disputes between the cantons. At the time, the cantons were, in almost every matter, independent sovereign states. Today, however, more and more power is centralized in the federal administration. The area of responsibility of the Federal Supreme Court, which was once restricted, has changed dramatically. The federal courts and the federal public prosecutor were very quietly turned into an instrument of the parties and their policy. So if a judge doesn't rule according to party values, he shall not be re-elected. This leads to an increasing loss of trust. And I think that the success of our judiciary initiative is a proof for that. If we vote for the judiciary initiative, it would be a remedy for the shortcomings which have increased in the last decades. Lawyers who think that they are professionally and personally suitable for the highest judiciary office, they apply to an independent and competent expert commission. This expert commission then examines the personal and professional aptitude of the candidates for this highest office of judge. And those people who pass this examination of the expert commission can take part in the lottery. Since the office of judges are very popular, I think that there will always be more candidates than vacant judicial posts. This process has clear advantages compared to the system today, which is defined by the political parties and which is highly intransparent. An expert commission, which is independent of the authorities and political organizations, can assess the candidates based on a certain catalog of criteria. Then it can grade the candidates using a scoring system and applying also killer criteria like a minimum age. And with that procedure, they decide who is admitted to the lottery. Of course, there can also be wrong choices. No one can say how a candidate develops over time, and how he or she proves herself. graduates with the best grades are not necessarily the best judges. Disagreeable developments are always possible. Therefore, the Judiciary Initiative includes an impeachment procedure, which we don't have in the current system either. The qualified lot procedure is scientifically substantiated, and it's based on numerous studies. For example, in the Richterzeitung, judges by lot, Professor Dr. Katja Rose, Dr. Malte Döne, and Professor Dr. H.C. Margit Osterloh. Compared to today's judge election system by the political parties, the qualified lot system only has advantages. It guarantees equal opportunities for all who want to become a federal judge. What is the most important factor for admission is the qualification. Today, people cannot apply for the office of a highest judge because they are not in the right or not in a political party at all. So people who are not willing to align themselves with party values cannot apply for this office. And this considering the fact that only 5% of our 8.5 million citizens are part of a political party. So the judges here are necessarily part of members of a political party. Actually, I would also want to touch upon the fact that members of parliament, for mercantile reasons, also do lobby work in 87 different commissions. And they say that they defend high values, but this is quite a strange argument. That's okay if these people are not allowed to define who is going to be a judge or not. Contrary to that idea, today, less qualified people can stay high federal judges because they want to have a high office. When we apply the qualified lot procedure, it makes sure that those who don't succeed in the procedure don't lose their face. There will be other opportunities where they can stand for election again, even if it didn't work the first time. The result of the system is that people stand for election which otherwise wouldn't do so. This is particularly true for women, because today there's a large disproportion between the number of female lawyers and the number of women in the Federal Supreme Court. Particularly women, but also other outstanding lawyers are just not ready to be members of a party because they want to stay independent. This is why experienced, free lawyers are underrepresented at our laws. As I mentioned before, the qualified lot procedure means that candidates can stay for election several times. The candidates which were positively assessed by the Commission stay in the pool. Therefore, the qualified lot procedure increases the potential to attract competent people. And then I would like to touch upon the fact that we have judicial clerks which actually work at the Supreme Court, but were not elected. people who don't win in the lottery don't have any disadvantage, because no one can say that they were incapable of working as a judge at the highest court. It also reduces the danger of people overestimating the self. Because the office bearer, the ones who won this office, are less subject to the danger that they overestimate themselves and misuse their power. The qualified lot procedure also breaks up old boy networks, prevents corruption, and improves the relationships between rival groups at the courts or in parliament, because everybody has the same opportunity. If our people vote in favor of the judiciary initiatives, our federal judges are still allowed to be members of a party. But the difference to today's system is that the lawyers at our highest court don't necessarily have to be members of a party to get an opportunity at all to work at the Federal Supreme Court. And if they are part of a party, and if they officially represent certain values, they don't have to change this appearance and values to get a to be able to work as a judge. As I said, only 5% of the Swiss population are members of a party. So it is also very strange to say that the appointment of judges according to the relations of the party doesn't actually represent the people. I think that you can say that today the parties actually sell posts which don't belong to them. So the first condition to get a post at the highest office means that future judges have to commit an illegal act. To put it bluntly, you could call this receiving stolen goods. And since they have to stand for re-election every 6 years, today's practice is a system of like a leasing business. And the fact that this tradition has existed for many decades doesn't mean that it makes it legal. The qualified lot procedure makes sure that candidates for the highest court cannot be politically planned. So parties cannot plan to bring their own candidates to office. Because today, since political parties can plan that, the judges turn into an extended arm of the parties in executive and legislative. So the qualified lot system rules out the possibility that only those who have done the best party work and political networking are able to run for the office of federal judge, and that they get that as a reward, but lack professional skills. And this qualified lot procedure also makes sure that federal judges don't align themselves with their party guidelines before they pass their rulings. It is should be impossible that parties assess their judges according to whether their rulings correspond to the party line. It should also be impossible that federal judges have reporting obligations from their parties. And to put it bluntly, you could call that performance reviews. The qualified lot procedure also makes sure that there is camaraderie with like-minded judges within the court and so-called collegial coordination with cantonal or federal lower instances. what is impossible for a constitutional state is what is a practice, but which is not allowed by our constitution, the part-time judges. They are not actually qualified and use the title federal judge and its advantages for their private business. Even if they are very diligent party members, this is simply advertising their own law office. Of course, many a lawyer would like to buy at the age of 27, which is very common in Switzerland, a federal judge office or federal judgeship at the price of 20,000 francs a year. The mandate he gets from third parties and the network he or she obtains are worth its praise. Of course, it is to no one's surprise that the political parties don't support the judiciary initiative. No one wants to relinquish their influence, and no one wants to voluntarily renounce a reliable source of income. It is also to no surprise that the Justice and Police Department disqualifies the Judiciary Initiative as non-traditional. Not everything that looks back to a long tradition is necessarily good and right, but this is something they haven't understood yet in our federal capital. I think that neither the parties nor the Justice and Police Department can actually argue what the advantages of today's systems are compared to the qualified lot procedure. I was considerably appalled by the argument from Bern that they don't want random rulings. As a matter of fact, they admitted that they want to keep influencing the rulings, that they don't contradict the values and opinion of the executive power. So if we need to talk about the danger of random rulings, this only shows how depraved and corrupt our system has become and how unrestrained the power of the executive has become.
Einwohnern schon gediehen ist. Die Botschaft des Bundesrates zur Justiz.
The message of the Federal Council on the Judiciary Initiative from the 19th of August 2020 states that the Judiciary Initiative lacks democratic legitimation. Their arguments are flimsy. Let me put it that way. If there was no democratic legitimation, the Judiciary Initiative couldn't have been admitted by the federal bodies. To admit this initiative and then to kill it factually with a flimsy argumentation saying it has no democratic legitimation is dishonest, untrue, and unworthy. If they are really concerned about democratic legitimation and don't just use this argument as a killer argument, we need to read the paper of Professor Cechnak. He showed years ago that the democratic legitimation cannot be ensured by parliamentary elections or by elections by the parliament. Democratic legitimation of judges is given through the law and the constitution. And this democratic legitimation is strengthened by the qualified lot procedure, contrary to today's system. Because, according to this initiative, judges who don't work according to the requirements can be impeached
Auch heute lassen sich prominenteste und fähigste Wissenschaftlerinnen und Wissenschaftler zitieren, die mit neuesten und wissenschaftlichen empirischen
Science is clear that the qualified lot procedure is what a constitutional state needs. The only ones who can be against it are people who want to keep their power and who see an enemy to their power in independent judges. In the Swiss system, a qualified lot system, Switzerland urgently needs to implement a qualified lot procedure to appoint our highest judges, as the Judiciary Initiative suggests. This procedure has clear advantages compared to the current system. It remedies grievances in our system and contributes significantly to the independence of the judiciary. It creates trust for the people looking for justice and guarantees the independence of our highest judges. With that, it meets the basic human need for justice. Thank you very much for your attention. Thank you very much, Adrian. That was a very concrete and clear speech. I am very much looking forward to our panel discussion. We are going to discuss an alternative proposition by Professor Dr. Peter Übersex. He is titular Professor of Public Law and Public Procedural Law at the University of Basel, Clerk of the Court and Scientific Advisor at the Federal Supreme Court in Lausanne. Peter, the floor is yours.
Thank you so much for having me. You will realize that I do not agree with what my previous speaker just said, not with all of what he said, or what the former president of the Constitutional Court said. Maybe I'm in line with what Ms. Sanders said. I will try to counter what was said before in line with Swiss traditions and customs. So, the title of my presentation is An Alternative Model. There is an array of different models. I chose the one that I think is the most appropriate. This is my development. You could have developed it differently. It's like building bricks that you put together. My focus is on the federal system, the federal courts, not just the highest courts, the constitutional court, but also the lower courts. This is not an appropriate system for the Attorney General's office because this is completely different. And it can only be seen as an overview, of course. Last week, I published an article that you are invited to read with more details. I do not want to go into detail on that slide. Much has been said before. Two things I would like to mention, however. Judges have their own attitude, their own opinions, and this is okay. There aren't unpoliticized judges. And I believe this is one of the weaknesses of the judicial reform. It expects judges not to have any views at all. Of course, their focus is primarily on the judiciary, but they have a basic opinion and attitude and understanding of the world, and it will influence their decision-taking to some extent. It does not mean that the political parties should exert influence on the elections. That's a completely different question. I also want to highlight that in Switzerland, we have the tradition of election by parliaments and sometimes even by the people itself. This is a tradition And this is because the judges are democratically legitimized. We do not have a tradition of co-optation, but this was mentioned before. I do not believe I need to explain the re-election processes. This has been done before. Where do I believe can the system be optimized? It was said before, we need a higher independence of political parties, not the political preconception, but the parties. The key criterion should be skills, qualification, what Mr. Gasser said before. But not just that, also social skills, how they work in teams. I believe this is very decisive. Their willingness to self-reflect and their realization of their own preconceptions of how they see the world. Language skills is another very important factor, social competence, knowledge of the law, of course. Let me go back to language skills. We have different languages in Switzerland, and therefore the judges need to command the different languages. And life experience. The higher the court, the more experience it takes. We should decouple the system from the party political distribution of seats. There are federal elections every 4 years, political elections. The parliament elections take place every 4th year. And during the course of those 4 years, one can never truly reflect the party political distribution in the courts. So you have that key, that distribution key, and the court's always trying to reflect that, but there is a delay. Sometimes you have to wait for a vacancy, then you can rearrange the seats to reflect the political distribution. It is difficult to completely reflect that, so I believe we should decouple it to some extent. I don't believe that you will create transparency at the federal courts through the judges' political preconceptions. Maybe our German listeners will see this as a surprise. It's not that false, but the composition of courts and their worldviews should also be reflected, as is the case in any population. Maybe we should see to it that the most important political tendencies, trends, parties are reflected, but of course the democratical parties. But in Switzerland, this might be easier to realize because of the concordance democracy that we have. It should be in line with checks and balances. Of course, one could think of a blocking clause. Other states might have such a restrictive clause, but Switzerland has not yet developed this. To say that a certain majority dominated the court, no, not in Switzerland, I wouldn't say that. Now, term of office, a single term. At the federal court, it's 12 to 15 years without re-election. I believe that would be the most appropriate version, would have been compensated by removal from office, but of course in line with a legal trial and legal protection. The Judicial Commission of the Federal Assembly could announce elections by public tendering. I agree with what Mr. Gasser said concerning the expert commission. They should revise the nominations, the suggestions, provide them to the Federal Assembly. The expert commission prepares the elections, and they would then, the Federal Assembly that is, could accept the suggestions, but the Federal Assembly could not decide who to nominate. So that would, of course, limit the Federal Assembly's influence. So the Judicial Council would not only be an advisory body, it would, well, I said it before, prepare the election, suggest candidates, and it could be similar to the list that we know from the ECTHR. Of course, you could be member of a political party, but that is not an obligation. But nevertheless, the candidates should disclose their beliefs. This is part of transparency. Otherwise, we will run the risk of appointing a judge, and in the end, you don't agree with the judge's beliefs, because we do not want to do a blind bargain. So they should disclose their beliefs, their views, and this, of course, would play a role in the selection process. Well, prohibition of mandate tax, that's obvious for me. Traditionally speaking, it is different than what someone might see at first glance. With real political mandates, it's the same, be it the executive or be it in the legislative branch. If one assumes mandates and there is a proximity to a political party, but I don't believe this is contemporary anymore. So this will be a new construction site, so to speak. Something that we will have to build, establish. One should also discuss how political parties are financed, but this would be a completely different conference. But the party tax is a question one has to tackle. How would the Judicial Commission be composed? There are different models, of course. Of course, one would need a legal regulation saying that the Judicial Council is independent, legitimized by and through a democratic process, that it's transparent, and of course all that needs to be communicated. As to how this can be implemented, there are different versions. You could say there is a concentrated version with a total of, let's say, 16 seats with judicial experts coming from the Judges Association, faculties, universities, the Bar Association, or an extended version where you would also have non-experts, like representatives from civil society, consumer protection, trade unions. I don't know why the federal court should be heard and consulted. Maybe you can explain that to me. You said it didn't have anything to do with cooptation, but still, You said the federal court should voice its opinion as to who should come. I see it differently. Maybe we can take up this question later. So, who decides who will sit on the Judicial Committee? That's another question. I mean, once you solved one question or one problem, you will be faced with another question. And this is another question. Who will sit on the Judicial Council? So this brings us to a gray area because we never surely know where they come from. So from a democratic perspective, it might be better to have the Federal Council and Federal Assembly vote or elect the Judicial Council. This would, of course, come with a higher level of legitimacy. First, elect the Judicial Council. But I said it before, there are different versions. But the Federal Council could be bound by proposals coming from the represented organizations. So this would be another checks and balances element. How to counterbalance these long terms of office? If one is elected for life or until retirement age, you need proceedings for impeachment. Of course, with clearly defined grounds. These can only be legal grounds, not political grounds. Let's say there is incapacity for office for health reasons or unworthiness of office for reasons of misconduct. We have not yet developed a legal protection system. I believe this would interfere with individual rights if we were to introduce such a system. Who should be responsible for these impeachment trials? It should not be the court itself. It shouldn't be the Federal Assembly either, because otherwise we would add a political element. I'd say it could or should be the Federal Council. The initiative says we need the principle of parallelism. I do not believe this is necessary. But of course, we need to reduce political interference. As to legal protection, we would have a legal court. That would be a new court consisting of members who discharge the office as a second job. You could also have a court of appeals on a constitutional level. I do not believe this is compelling, but one could suggest that. The Justice Court would consist of part-time members elected for one term, adjudicate judicial proceedings, possibly a court of appeal. And now my overview. A Federal Council appoints the Judicial Council as an expert body bound by the proposals of the represented organizations. The Judicial Commission prepares the election, announces the candidates, goes to the Federal Assembly. They accept it or reject it, but it's bound by the Judicial Commission's suggestions. Affiliation to a political party is not mandatory. You can be a member of a political party, but it's not necessary. It's not compelling. Judges can be removed from their office on grounds of unworthiness of office or incapacity for office. I know that this model is more complex than the one we have right now, but I believe it is necessary. It would come with benefits. Election, re-election, and also removal would be independent from political parties without taking away the democratic feedback. So the Federal Assembly would still be the election body, but with limited powers. The federal courts would still be democratically legitimized. So if this is to be implemented, we need a constitutional revision, because in the Constitution it says that the term of office is 6 years. But I don't believe it's wrong to go through the Constitution. And it's independent, this model, independent of the judicial initiative, the judiciary initiative. It is a block system. You can, like a puzzle that you put together. And I'm not saying that this is the only model that could work. It is one of many different models that could work. But we heard a lot of criticism and skepticism. We can, of course, discuss this later on. And there are two major differences when comparing this to the judiciary initiative. When you stick to the consociational distribution of seats, you still have the representation of different views, but it still upholds and even strengthens the democratic legitimacy, because the election is done by the assembly and not by the drawing of lots, where in the end you wouldn't know who would sit on the council and who would have which mandate and which office. Well, thank you for listening.
Thank you, Peter. That was very detailed and concrete. Thank you very much. I'm looking forward to our panel discussion. We're also going to talk about the fact that the National Council decided this Tuesday that they want to recommend to refuse the judiciary initiative and that they won't make another proposition, a counter proposal. So you either decide in favor of vote in favor of the judiciary initiative or for the current system. So the National Council has already decided. It's going to be decided in the Council of State. So before we start, I see that Mr. Voskuhle, Mr. Grimm, and Ms. Nusberger are still part here. They're actually not officially taking part in our panel discussion, but if you want to introduce your considerations from an external point of view, you're very welcome to participate. So I think that everybody except from Mr. Meyer today agree that re-election are a source of danger. So, Mr. Meyer, what do you say about a one election process and the possibility of impeachment? No, I wouldn't refuse that system. But I don't actually welcome changes that are not necessarily necessary. I don't see that these changes are necessary. Mr. Übersachs asked me a question, I would like to answer it quickly. They said that the Federal Supreme Court doesn't understand, that they don't understand why the Federal Supreme Court wants that they are involved in the appointment of judges or considered. So the problem is that the list of candidates goes to the administrative courts at the moment in the current system, and these courts then make a statement about the quality of the candidates. Now that leads to the circumstance that people that are not qualified cannot be appointed as candidates. So I think that that is the system for the administrative courts, and it should be applied to the Supreme Court as well, because I think we know what qualification needs for our posts. Thank you very much. Maybe not only that the federal court, they theoretically, of course, know what the responsibility, the areas of responsibility is, but maybe the court where the candidates come from knows whether they're qualified. So when it comes to the judiciary initiative, Mr. Gasser, you said that the impeachment process that goes along the judiciary initiative is an element to improve the democratic legitimation. That is clear. But then the initiative suggests that the Federal Assembly, that it should go through the Federal Assembly on the request of the Federal Council. What do you say? In this matter, the initiators would like to be more precise. We are part of the state, we are part of Switzerland. We don't want to change everything from scratch. This is not necessary. But if to our surprise, it is said that the democratic legitimation isn't realized in the qualified lot process, I must say that if there are weak points, or if there is a problem about the values, if a large part of the population cannot assess the values of a judge, then the parliament, which is actually elected by the people, should assess whether a judge is apt for his or her office or not. Now, I want to point out that this is all about the right of a litigant before the legal instances, because people looking for justice today, and I think the discussion shows this, have the impression that the jurisdiction or the judiciary has lost its connection to the people and the population, the people. It only reports to God himself and has no other ground or legitimation. So I think that our proposition improves that circumstance. If you talk about democratic legitimation, and if you say there is something that is not supportive in the Swiss mentality, you can, or in the mentality of the judges, you can tell them to speak an oath. Well, I don't want to touch the academic field about that, but our judiciary initiative received 130 signatures, and that shows that the trust in the judiciary of the people isn't given anymore. That there is an impression that the judiciary and the politics are too much intertwined, that they build a political class which distributes its power among themselves, and that they are all united on a Titanic, on a sinking Titanic, but doesn't listen or protect the third-class people. Mr. Meyer would like to make a statement about that. Mr. May. Thomas, is it okay? Mr. Gasser, there is a contradiction in your line of argumentation. You say that we, the federal judges, are intertwined with who knows whom. I never was. I never was for 34 years. I have never reported to anybody about my rulings. I don't know where you got this impression from. And on the other side, you say that the judges live on a different planet, that they lost their connection to the people. For me, this contradicts each other. So do you know any concrete examples where authorities or where judges listened or were influenced by authorities? Are there rulings you know which were clearly influenced by other branches? And I have to tell you, I don't live on the moon. I live in Lucerne, and I know that people there trust the judiciary. I'm sorry, I have to interrupt you. I would like to have a different discussion because we're not doing politics here. What I would like to talk about is that we have statements from Greco, we have statements from the first part of our conference which say that there is need for change. And we have arguments on the table that show what we could do to change the situation. And I would rather talk about that than about the political grounds. Could I just make a quick remark as an answer to Mr. Meyer? I would just like to briefly point upon the following fact. The NZZ, which is a leading paper, were advised for many decades never criticize a ruling of the Federal Supreme Court. 4 or 5 years ago, this newspaper wrote that there is a regulation of authorities that doesn't that influences the judges so that they can't pass rulings in a certain matter. So the Federal Supreme Court is the extended arm of the executive. And if you take the case Donsala, they didn't just decide independently, but it was aligned with the Federal Finance, Department of Finance, which was led by Mr. Maurer. That was also aligned with the party values of the Swiss Popular Party. Also, your influence could suit to talk about certain rulings in the Swiss in the Swiss TV. So that's a very important matter. We are limited in time, and I have to interrupt you. I'm sorry. It is quite difficult to host this discussion because I would like to have a structured discussion. So we wanted to talk about re-election and impeachment. We saw that there are two models which we can discuss in its concrete implementation. Now, here's a question to the observer from the outside. In Switzerland, the judges are elected according to party ratios because they say that this represents the values or the opinions of the people. So Switzerland doesn't have this system. Does it mean that we don't have a diversity of fundamental values at the courts, or what do you say? Thank you very much. I don't think that we lack diversity of judges. The Federal Constitutional Court has this established way of electing judges. We also have the election of judges for the highest offices, and for the lower courts, there is no party influence. But I don't think that we lack diversity because of that. I'd rather say that today not all our citizens feel represented by parties. I think Mr. Gasser said that we need to ask ourselves how many people the parties actually represent, because there are many people who don't feel represented by parties, and they would need to be represented in the court too. I think that the independence of courts is very much dependent on how we assess them, their independence. Of course, diversity is important, but we can reach this diversity in other processes too. And last but not least, we need to pay attention to the misbelief that diversity is the only guarantee for a fair trial or ruling. I am pro-diversity, of course, men, women, political, religious, sexual orientations, but just because somebody has a particular sexual orientation or political stance, they can still understand other people's situations and living conditions, because if we don't believe that that only, for example, a gay person can rule over gay people, or Christians over Christians over Christians, we couldn't believe in our legal system anymore. Peter, I think you want to complement what she said, because you say that the judges have to, because the judges still have a worldview. I have to unmute myself. As I already said, we need to know the judges we appoint. We can also establish a professional committee that only checks the professional qualification, and then we also lack diversity. Lack of diversity is also always a problem, no matter from which point of view. It doesn't matter which political view or world view we talk about. So I'm convinced that the candidates need to talk about their values and about their political stance on, for example, abortion, or the division of tasks in a partnership, and so on. So I don't know how to assess that in the end. That's another question. But I think that we need this transparency in the election process of judges, because like that, I think that we will achieve a representation, a diverse representation of our population or people. So, Ms. Sanders, what do you say? Mr. Voskuhle would like to say a few words. Yes, Mr. Voskuhle, please. The floor is yours. I would just like to make a small remark. If you say we don't know the judges we appoint, in the Federal Constitutional Court in Karlsruhe, we made the experience that seemingly conservative people were elected to the court, and then they turned out to be quite revolutionary, and vice versa. So I think it's very difficult to make a prognosis on what people decide when they can decide independently. So I just wanted to share my experience with that question. Thank you very much. So I would like to say a few words about that. I completely agree, but this is not a fundamental problem from my point of view. I think that judges should think independently and develop. But at the starting point, at the beginning, there should be a certain transparency at the point of election, of course. But of course, then we can't influence how people develop. This goes without saying. I agree. Anne, what do you say? I would like to relate to that. I think I wouldn't want to make a prognosis. What I like about the appointment, or what I think is difficult about the appointment of judges in the US, is that in the processes where they are questioned, everything what they ever wrote and ever said is examined, and I think that this goes too far. I think that the values of the judges are important, and we need to aspire to have a variety of personalities in a judicial board. But I think that the people should, the person themselves should be able to develop. Mr. Meyer, you said that in your long work at the Supreme Court, the judgments were never passed along party lines. So how can you actually justify or make an assessment on whether rulings are passed according to party lines? Well, actually, I completely agree with you. I always told the Judicial Commission, you need to admit candidates which don't belong to a party if they are professionally qualified. Of course, we would have great problems with the European Convention on Human Rights if it was binding or mandatory that candidates for a judicial office need to be member of a political party. But in the current political system, it is actually the case that the seats for the Supreme Court are distributed between the parties, and they do not want to appoint judges which are not part of a party. And Peter, you know from your own experience, because you have been serving on the court for a long time and you are not part of a party. In 1943 was the only time that a judge was elected not being part of a party. I don't know which party he paid to. I'm sorry, Mr. Gasser. There was another very important judge in family law who afterwards went back to university, and he wasn't part of a party. But Mr. Schubert was a professor, then he wanted to become a judge in Basel, then he asked what party he needs to join. And then they said the Swiss Democratic Party, and he joined that party. It didn't correspond to his values, but it helped him to become federal Supreme Judge. And then he was thrown out by lobbyists, not by the parliament which elected him. And of course, we can ask ourselves, why did the parliament accept that the federal judges worked as a club who were able to throw out their own member? Because that would have been the task of the United Federal Assembly. Well, that shows that there is an entanglement of these two branches, and that we need to renew and refresh our system and reflect our system. I very much agree with the scientific representatives and also with the proposition of Peter Übersachs. If there is a will to implement independence and to have a more professionality, then we want to talk about it. But this proposition was refused by the Federal Council because they said and argued that the Federal Council was against this and the Federal Court as well, not giving a counter proposition. Now, I know federal judges who weren't present at this vote. Now, what I ask you is whether the federal judges, which were freely voted, are they part of a club or association? So a litigator, somebody looking for a judge is a normal person, an average citizen, a taxpayer. Well, this person has no chance to stand against the judiciary, which is led by the authorities and influenced by the legislative. So we have no power against this system. And it doesn't... you are right with your examples. About Mr. Schubert, there was a problem. We already talked about it today. And you also talk about it in your initiative, that there is the possibility of impeachment. We don't have that yet in the Federal Supreme Court. We only have it in the other lower instances.
I would like to ask another question. You mentioned the expert commission and the judicial initiative. You said they should vet their pre-selection much better and prepare it much more intensely. And then the Federal Assembly has to say yes. They can say yes or reject, but they cannot take someone else. Why in the end is that still necessary? If there is such a selection, then just like the initiative suggests, the perfect person, the appropriate person could just go and the assembly could roll with it, basically. It's a question of democratic feedback to me. I would like to tell you an anecdote. Last fall, I took part or listened to a Zoom conference. It was about an English court at the High Court. He gave a talk. It was a very exciting presentation, quite fun actually, I must admit. But then the question came up as to what benefit Europe brought according to British legislation. Well, from continental Europe, they received proportionality. That was something they were taught. He didn't say they were forced to do it. It sounded like it was something they felt forced to. He said they were taught proportionality as a concept. And this does not reflect British tradition at all. And he said that he had a problem with it, because when authorities' decision needed to be checked for proportionality, then he is a norm judge, but in the end it's the authority to decide, and they need democratically elected members. And that really opened my eyes. A judge, him or herself, can tell themselves to be modest, to maybe hold back because they are not democratically elected. So the judge thinks how they can vet a decision coming from a body that is democratically elected. And I believe in Switzerland we have a special feeling for that democratic legitimacy, and this has to do with our state system, with the democratic mechanisms that we have and that we're proud of, rightly so, I must say. This is a long tradition in Switzerland. And now saying the expert commission is to decide, or it's a decision in a lottery, then I'm convinced that we continue to need the Federal Assembly, but the political influences need to be defined. And I believe the political parties shouldn't be able to exert as much influence. They could still do it if they continue to submit the suggestions. And it has to be an election after all. But then the expert commission would come with their own suggestions. So, I mean, I presented my model and I'm convinced of it. And we have different models in Switzerland and in Germany. And I pointed to Mr. Tschentscher's PhD thesis. He talked about this chain of legitimacy going back to Roman Herzog. And it was really well defined. Tschentscher said it wouldn't fit to the judiciary. This chain of democratic legitimacy wouldn't fit, because let's say someone doesn't fit anymore, then this person would have to be removed from office, and this isn't something we want. So Mr. Tschentscher says the actual democratic legitimacy for the judiciary is to be found in the Constitution, in the legal text. Now, I believe that this has never been taken up in Switzerland. Maybe that's a topic for the German colleagues then. Ms. Sanders, I believe that this discussion of the democratic legitimacy is something we cannot avoid in Germany. I believe that this is a good discussion that should be conducted. And these questions pertaining to the re-election process, they're quite complicated. But whenever we work on these standards, how can we anchor these standards? Is it a rather more general standard? And many countries think that the judges' democratic legitimacy could not be demanded because of these reasons. Because they say we need to separate powers and we should take politics out of it. We should keep it separate. Of course, there should be a selection before election. We mentioned Article 18 from CCJE. Some countries choose a way of democratic legitimacy, but the judges' democratic legitimacy could actually come from the Constitution and from the legal text. So I believe that the national constitutional traditions are still a good foundation. I don't believe this will prevail in Switzerland because they have their own tradition and they don't seem to be able to get away from it. We could go back to Mr. Übersachs's model suggestion and also discuss what was said before, also by Mr. Grimm. Mr. Grimm, can I make a follow-up question? The Constitutional Court in Wiesbaden, why did it question its own legitimacy? Because it was a federal state and it wasn't legitimized by a parliament and it wasn't democratically elected? Am I mistaken? No, the administrative court in Wiesbaden asked itself, because it wasn't elected by parliament, but it was appointed by the Minister of Justice, and therefore it developed this thought. And I mentioned these standards, Venice Commission, CCJE, you name it, and they see a completely independent judicial committee as the golden standard. That's a new tradition, and it's a discussion that has been conducted by German prosecutors and lawyers, or the judiciary as such. Traditional democratic legitimacy needs to be developed without political interference. In Switzerland, it's really frowned upon to have the executive appoint courts. This is not seen as independent. Yes, that's this traditional link, which we also need, because Europe cannot be a continent where everything works and is done the same. And I mean, you can criticize me, no problem. My field of expertise is in civil law, but with the election, the parliamentarian, the minister, this needs to be a chain without interruptions until it reaches the executive. And in Switzerland, we say election by the people or by parliament. We have 10 more minutes. And for the final round, I would like to mention some buzzwords. And then you can decide which buzzword to take up and what you want to discuss. Peter, what you said, you mentioned the Federal Council and their suggestions and the capabilities of the Federal Assembly, and there was a clear no, and the election was confirmed in the end. And that's actually a confirmation of what you just said. We received many questions. You have covered many questions before. But maybe we can take up some aspects. Appointment for life, that's a nice buzzword. Fixed retirement age. What do you think about anonymized applications? Many questions pertaining to the judge's legitimacy, the judge's beliefs and attitudes. Can a judicial committee only assess judicial expertise, or can it also assess other fields of expertise? And a question, because we heard so many different suggestions and we got so many ideas. Without constitutional changes or amendments, what can be implemented immediately? Couldn't the Judicial Committee solve these deficits itself? So these questions could be shed light upon from different perspectives. And the Council could work on different bodies. So what could the judiciary do itself? So we received many different questions, and maybe you can pick specific buzzwords and share your thoughts. So who should start? Now I see Thomas Stadelmann speaking, but he is muted. Let's start with Mr. Meyer, because he was the first to deliver his speech, and then we can continue with Ms. Sanders, like we had on the agenda.
Uli?
Ja,
Ulrich, do you want to start?
in der Tat, dass man eben die Arbeit der Gerichtskommission und die Zusammenarbeit mit dem
I believe that the work of the Judicial Council and its cooperation can be improved without having to change laws. I believe this is a doable solution. I would like to highlight, and I would like to mention a very concrete case. It was in July 2018. An independent judge of the higher court in a Swiss canton applied, but he did not go to the political party's HQ. He was invited in due time. Everything was done by the book. They talked, they had their interview, but they found out that he is not a member of a political party, and they told him he could go home.
Mit Ausnahme einer Zeitung hat natürlich niemand darüber berichtet.
And it was just one newspaper to report that incident. Everyone ignored it, but now, 3 years later, everything is wonderful. But the ordinary Swiss, they lost their trust in the system. Because I'm a layman, I'm an auditor, how could I collect 130,000 votes in a short period of time? Something has to be wrong. So I said it before, political parties sell these mandates. And this is illicit because the candidate then buys a mandate that doesn't belong to the political party in the first place. So all these vacancies during the last 50 years, how were they filled? No one filed a complaint, or did they? How were they filled? But what I like about the current state of affairs is that this discussion has reached the public. People want to improve the system. We need independent, capable judges. And we need to keep them. Thank you so much. Ms. Sanders. And then Stefan Breitenhof. I mean, I represent an external view. So it is more difficult for me to assess where we are in a given system. You know the Swiss perspective much better. You know what is the best path to embark on. But what can be done now? Well, I believe we can build on this culture of independence, but it is paramount for all parties involved to observe these barriers, these boundaries. And I believe that's a solid footing. I have figures from 2018. 54.2% of all Swiss say they trust the system. I still believe it is important, and it is a central advantage of this judicial initiative to have given a platform to this discussion. It has reached the public. Of course, you can always improve things. Peter? I would like to say one thing first. I don't agree with what Mr. Gasser said. I've been at the federal court for 30 years, not as a judge, but I've been there now for more than 30 years. And most of the cases do not have a political component. And this doesn't play any role as to where judges come from. But there are single cases. And it can be all different kinds of law, civil law, family law. There are cases where it has been politicized. And the people taking recourse to law will in the end say that this has been a politicized case. But in most cases, it does not play a role. But that's actually not a problem to me. I see it like Ms. Sanders. It's about the appearance. It's about the chilling effect. If a judge won't be influenced at all, and I believe that this is the rule, still, it's about the appearance. People might believe there is a close link between the judgeship and political parties. And if we have that appearance, then that's it. Let's say judges are biased, and there is reason to believe they're biased, and this is the end. So it's about appearance. So I understand that people believe this should be changed. My trust in politics isn't very high, and I don't believe that the Judicial Committee is willing to act on what they said. Because in the end, it's about power. It's about political power, and political parties are not willing to reduce their power. This is how I see it. That's my assessment. Mr. Voskuhle, would you like to chime in? I would like to come back to the appearance of independence, dependence. The former president of the Polish Constitutional Court and I had a long discussion. I wanted to know why the Polish Constitution is being attacked. And he said that we failed to communicate how we work, how we think, and how independent we actually are. And that is why we lacked public support. And this told me that we did not only have to look at the inside, and I know so many things are working well in Switzerland and in Germany, but still we need to do our utmost to communicate, to reflect standards, and to explain to people why we do our work and that we do our work good. And then in times of crisis, we can count on the people's support. So this is my perspective, to shed light on the inner perspective, but also have the outer perspective, and to communicate that, to tell people that we do independent work, good work, and it's also about appearance. And this is what Mrs. Sanders talked about. Despite the differences, we need to make sure that we communicate the good to the outer world, to align international standards, so we have that trust that is necessary. Wow, that would have been a very good conclusion. But I still have a question, a Swiss question. The National Council, I said it before, said on Tuesday that the initiative was rejected. So how could we continue? Can we hope that there might be changes at some point in time?
So as far as I know, this now goes to be discussed by the Council of States. And we know that the former council Mr. Stöckli always said that this chamber is the chamber of reflection, so maybe something's going to change. The Federal Counsel Vera Rottenberg said on the 18th of April at the University of Zurich, when she was appointed to the University of Zurich, she said that she had never experienced any influence by the party, but there was also a political pressure who was increased in the last few years and which is still increasing. So we're turning our system into a more and more centralistic and administrative state, be it in good faith or bad. But every state system needs to be backed by a judicial system that passes its ruling in according to the will of the people, not of the authority. Please, no politics here. So I support everything that supports the independence of the courts. Thank you. Peter, please. I think it's interesting and important to see that the Council, the Federal Council and the Parliament say that we need to change the system. And at the same time, they don't want to do it either through the initiative or a counter proposition. It is their right to do that, but there are of course people or members of parliament who say that we get back to it. But what does it mean, getting back to it? I hope that it doesn't end up in a drawer. But I think that the members of parliament should look forward and anticipate what can happen in the future. Of course, they can take their time, but still, I think it would be good to develop a new propositions of a new system, at least in the midterm. So let's hope that the Chamber of Reflection reflects a bit on that topic. The hope dies last. Thank you very much for participating in this panel discussion. It was very interesting. So we are concluding our conference. The large number of participants and the intensive discussions showed how important and urgent the problem is, which we discussed. Judicial independence and separation of power are cornerstones of our democratic constitutional state. We have always said that these cornerstones shouldn't be taken for granted. Or as Professor Nusberger put it, to be independent and to appear to be independent is not given once and for all. It is something that the courts re-established with every of their rulings. So the problem is that we lose trust faster than we gain it. Particularly in the last few years, we've realized that the situation can change dramatically in a short amount of time, and that a democratic constitutional state in an extreme case can turn into a majority dictatorship. The VDEM Institute from the University of Göteborg stated in its Democracy Report 2020 that the autocratization, which is the decline of democracy in states, accelerates all over the world. For the first time since 2001, autocracies are the majority, 92 countries. Almost 35% of the world population live in autocracies. That's 2.6 billion people. The EU has its first non-democracy as a member state. Hungary is now assessed as an authoritarian electoral regime. In its 2021 report, the VDEM Institute states that the global decline in the last 10 years is sharp and continues in 2020, particularly in the Asiatic Pacific region, Central Asia, Eastern Europe, and Latin America. The level of democracy for the average world citizen sunk to a level in 2020, which corresponds to the level in 1990. Let me remind you that that was just before the fall of the Iron Curtain. The liberal democracies shrinked from 41 countries to 32 countries in the last decade, with a proportion of the world population of 40%. Eastern European states such as Hungary, Poland, Serbia are continuing their downward trend after continuing attacks on the judicial system and restrictions for media and civil society. In its Liberal Democracy Index, the VDEM Institute states cornerstones of the constitutionality, like equality before the law, individual freedoms, restrictions of the jurisdiction, and so of the executive, and so on. This index in Turkey shrank from 0.46 in 2009 by 0.35 points to 0.11 in 2020. Turkey, as well as Hungary and Serbia, is now assessed as an authoritarian electoral regime. In Hungary, the index also fell by 0.39 points to 0.37, in Poland by 0.35 points to 0.49, and in Serbia by 0.28 points to 0.24. The Democracy Barometer of the University of Zurich and the Center for Democracy in Aarau shows similar developments. Between 2000 and 2016, the average index in the EU fell from 62.98 to 54.73 points. It is interesting that in the older EU states, it fell more sharply than in the new member states, namely from 75.35 to 65.42 points. So that's only slightly higher than the average in 2000. And then we have the Transformation Index of the Bertelsmann Foundation. This measures the separation of powers, judicial independence, prosecution of office bearers who misuse their positions, and so on. The current index 2020 shows a problematic balance for the last decade, because the separation of powers was weakened in 60 states, for example, in Poland, Romania, Serbia. So that's about the current developments in Europe. If you look at what is happening in Europe, but also if we consider the political polarization of politics in Switzerland too. In Switzerland, we cannot trust that will go well in the future just because it went well in the past. If there are members of parliament who say that Switzerland is a dictatorship, this is only politics. But such statements, but also punishments by not re-electing judges or office bearers, this is something we need to take seriously, because they're a sign of an increasing polarization and popularization of politics in Switzerland too. In daily newspapers, it was stated that saying that Switzerland is a dictatorship is a breach of taboo. And Ms. Sanders said it right. Even if the system traditionally worked well in Switzerland, these boundaries can break very quickly in an increasingly polarized political world. The discussions and speeches today showed that we are not helpless when it comes to these developments. Our state and national and supranational institutions have the opportunities to take measures, and they have begun to do so. I would like to point to the very bad situation in Turkey here. What is also needed is the commitment of the civil society, NGOs, and the support of science, because they need to call for the rule of law and the separation of power and independent judiciary. We also need the the circumstances so that judicial independence, separation of power, and the rule of law can persist even if they are subject to pressure. This is particularly important if you consider the fact that the autocratization of states always follows a similar pattern. First, the ruling parties attack the media and the civil society, then they polarize the society, then they disregard opponents, and then they distribute false information and undermine formal institutions. Today's conference made a contribution to the commitment of science, NGOs, and civil society. Thank you very much for that. Above all, the speakers who very spontaneously confirmed their participation, for example, with the remark that this topic is so important that they will definitely take their time to participate. Thank you very much. This conference wouldn't have been possible without you. Thank you very much to Mr. Peter Übelsachs, who developed this idea together with me and my colleague and friend Stefan Breitenmoser, who, together with me and the Swiss Institute for the Judiciary, turned this idea into a reality. I would also like to thank the University of Basel, whose Faculty of Law underlined 2 years ago already how important the commitment for the rule of law, the separation of power, and the judicial independence is currently. With this first Basel Conference on the Judiciary, the oldest university of Switzerland sets a clear signal that in Switzerland too, and particularly in Switzerland, the constant commitment for this cornerstone of our democratic rule of law is important and is important. Our technical, I would like to thank very much to our technicians, Marin Connu and Mr. Kurat, and thank you, dear participants, that you have shown your interest in judicial independence, separation of power, and the rule of law, and that you commit yourself to their strengthening. Now I come to the conclusion of our conference. I hope that we will see each other again next year at the second Basel Conference on the Judiciary, including the speakers. And then I hope we will be able to meet in person and exchange our ideas personally. Thank you very much for your participation and have a nice evening. Stay healthy.